So, number 15, please, number 28, 29 to 41, page 5, number 42 to 48,
Each time is granted to the needs. Objections for Rule 11 HGP is to take notice and file objection. HGP to take notice for the first respondent, issue notice to the second respondent, post after service of notice to the second respondent. To notice ತಗೊಂಡಿಲ್ಲ CGP to take notice and file objections. Urgent. ಆಯ್ತು ಇವ್ರೆ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು ಹಾಕ್ಲಿ ಅವರು. How can I fix a date? This is the last day of my roster, no? ಆಯ್ತು ಇವ್ರೆ ಅಲ್ಲಿ HGP to take notice ಅನ್ನೋದು ಆಗಿರ್ಲಿಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ ರಿಲೀಸ್ ಅಂತ ಅಷ್ಟೇ ಆಗಿದೆ. ರಿಲೀಸ್ ಅಂತ ಅಷ್ಟೇ ಆಗಿದೆ ನೋಡಿ ತಾವು ತೆಗೆದು ಆರ್ಡರ್ ಶೀಟ್. ಎಸ್ HGP ಏನ್ ಮ್ಯಾಟ್ರು? HGP to take notice and file objections. Urgent. ಸ್ಟೇ ಮಾಡು. ಏನ್ ಮಾಡ್ಬೇಕು? ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ? ಏನ್ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಹೇಳಿ? ಏನ್ interim bail ಹೇಳಿ? What is the offense? Then what is the urgency? What is the urgency? What is the urgency? Today is half day, you know. Bedi ಅಷ್ಟೇ HGP to take notice and file objections. Yes, HGP to take notice and file objections. ಏನ್ ಕರೆಯೋದು? Counsel submission. Officers raised objection that typed copy of the manuscript is to be filed. Counsel has made a submission that Annexure G is legible. On perusal of Annexure G, office is justified in raising the objection that typed copy of the manuscript is to be filed. Accordingly, week's time is granted for the petitioner to comply the objection. In the meantime, HGP to take notice and file objections. Yes. Ravindranath. HGP to take notice and file objections. Same order. Same order. Yes, same order. Sir, I have to hear the other side and file objection. Sorry, what are you meaning by dispensation of the notice to the PP and then address the arguments? What do you mean by that? ಬರೀ ಅಲ್ಲ ಅದು ಯಾವಂದ ತಲೆ ಹೊಡೆದಿದ್ದೀರಿ ಬರೀ ಅಂತೇನು ಹೇಳಿ ಬರುತ್ತೆ. Yes, HGP to take notice and file objections. Yes. HGP to take notice for the first respondent, issue notice to the second respondent and post this matter after service of notice to the second respondent. ಏನದು ಲೆಟ್ರು? ಅವತ್ತು ಒರಿಜಿನಲ್ ಆರ್ಡರ್. This court by order dated 11th April 2022 directed the learned special judge to conclude the matter at the earliest. And Bellamma. This court by order dated 23rd of June 2022 directed the, while rejecting the bail application of the petitioner, with the direction to and directed the trial court to conclude the trial on or before 31st of December 2022. First up, a letter is addressed by the learned principal district judge, Chitradurga, whereby the learned trial judge sought for the extension of time to conclude the trial. First, perused the letter, satisfied as to the progress made in the trial. First, accordingly, time is extended till 30th of June 2023 to conclude the trial. Yes, please. Yes, what is the recovery from you? Yes, Mr. What is your objection? Arms Act ಎಲ್ಲ ಇದೆ. When were you arrested? Where is your voluntary statement? Read it. Yes, let the CGP file objection. CGP seeks time to file objection again. ಬರ್ತಾರೆ ಪಾಸ್ ಓವರ್ ಮಾಡು. ಪಾಸ್ ಓವರ್. ನಾಗೇಂದ್ರ ನಾಯಕ್. ಏನ್ ರಿಕವರಿ ಇದೆ? January arrested. ಹೆಂಗಾಗತ್ತೆ ಇವ್ರೆ, ನೀವು ಚೆನ್ನಾಗಿ ಹೇಳ್ತಿರಲಿಲ್ಲ. ಎಂತದ್ದು? ಆಗ್ಲಿ ಬಿಡ್ರಿ. 438 ತಾನೆ. RC Nagendra Naik and HGP. Petition under section 438 CRPC with the following prayer. Three facts of the case are ascended. Srimati Savitrama, a housewife, lodged a complaint with Chenpatna Rural Police on 27/9/2022, which was registered in crime number 259 of 2022 for the offence considered under section 392 IPC. Next para. Gist of the complaint governments revealed that about 2 years earlier to the lodging of the complaint, son of the complainant had gifted a gold chain to the complainant weighing about 33 grams, and she was wearing the same. First, on 27/9/2022 at about 12 noon, when the complainant had been to graze the cows in the coconut garden, a person came on a black colored Pulsar motorcycle, and another person was standing near the motorcycle, and one of them inquired as to why she is grazing the cow in the somebody else's agriculture land, and sprayed something on her face. And when the complainant was trying to rescue herself, said person snatched away the gold chain weighing 33 grams, worth about 1,35,000 rupees, and both of them escaped on the motorcycle. Based on such complaint, police registered the case against unknown person. First, petitioner apprehends his arrest in the matter on the ground that ಅವನೇನಾಗಬೇಕು ಸಾವಿತ್ರಮ್ಮಂಗೆ ಅಲ್ಲ. ಈಗ ಯಾರೋ ನಿಮ್ಮ ಮುನ್ರಾಜು ಎಲ್ಲಿದ್ದಾನೆ? ಇದ್ರಲ್ಲಿ ಎಲ್ಲೂ ಇಲ್ವಲ್ಲ. ಮುನ್ರಾಜು ಏನಾಗ್ಬೇಕು? ಆಯ್ತು ಇವ್ರೆ, ಮುನ್ರಾಜುಗೆ ಇಲ್ಲಿ ಬೋರ್ಡಲ್ಲೇ ಇಲ್ವಲ್ಲ. Arrest that a crime constable by name Munraju is having a daughter and sister, and the petitioner had a love affair, and in order to snap the relationship, snap the relationship, said Muniraju is trying to fix the petitioner in the said case. First, he approached the district court in Simis for grant of anticipatory bail in Simis number 1158 of 2022. First, he said the request was rejected by order dated 23rd December 2022. Thereafter, petitioner is before this court. Next para. Shri Nagendra Nayak, learned counsel for the petitioner, reiterating the grounds urged in the petition, vehemently contended that admittedly the case came to be registered against unknown person, and on account of the previous enmity, one Muniraju, who is a crime constable attached to the police station, is trying to fix the present petitioner in the said case. And if that should happen, the petitioner would be put to untold hardship, including the marriage proposal being cancelled, and the marriage proposal is with the sister of the said Muniraju, for which the other members of the family have agreed, and even invitation cards are printed. He also contended that petitioner is not having any antecedents, and he would appear before the investigation agency and cooperate with the investigation agency, and sought for grant of anticipatory bail. Per control and HDP opposes the bail grounds. Next para. Perused the material on record meticulously, the real contents of the parties. Admittedly, the crime came to be registered against unknown person on 27th of September 2022. Till today, no progress has taken place in the case for want of presence of the petitioner. Whether at all the petitioner is responsible for the alleged act or not cannot be decided by this court at this stage by holding a mini trial. It is for the investigation agency to investigate the matter and file appropriate report as is contemplated under section 173 CRPC. Next para. Taking note of the fact that the investigation has crippled for want of the petitioner, directing the petitioner to join the investigation and cooperate with the investigation agency would meet the ends of justice. Accordingly, following order. Petition allowed. Petitioner is directed to appear before the investigation officer on 28th of April 2023 at 10 a.m. Investigation officer is at liberty to take him to custody and complete the custodial interrogation on the same day before 6 p.m. Thereafter, the petitioner be enlarged on bail by taking a bond in a sum of rupees 1 lakh with 2 rupees per lakh Amicable Ramnagar district without prior permission. Objections hackle ಅವರು. CGP seeks time to file objections again. ಇದರಲ್ಲಿ ನೋಡಮ್ಮ, ಇದರಲ್ಲಿ ಇನ್ನೊಂದು ಯಾವ್ದಕ್ಕೆ ಇದರಲ್ಲಿ ಕಂಪ್ಲೇನೆಂಟ್ ಬರ್ಕೋ ಬ್ರೀಫ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಆಫ್ ದಿ ಕೇಸ್ ಆರ್ ಅಂಡರ್ PS Raju, son of Sujay lodged a complaint with Chenpatna Rural Police so for the offence under section 392. Gist of the complaint government revealed that when the complainant was returning to his village on 1/11/2022, on a motorcycle bearing number KA 42 EC 9735, wife of the complainant raised alarm that somebody has snatched away the gold chain. Immediately, the complainant stopped the motorcycle and saw that 2 persons had escaped from the scene on a Pulsar motorcycle. Based on this one, tell them out, make it the same. ನಿಜವಾಗ್ಲೂ ನಿಮ್ಮನ್ನು ಕದ್ದಿರ್ಬೋದು ಮದುವೆ ಮಾಡ್ಕೊಳಕ್ಕೆ. ಪೊಲೀಸ್ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಅಪಿಯರ್ ಆಗಿದ್ರೆ ಅವನು ಸಾಚ ಅಂತ ನಾವ್ ಹೆಂಗ್ ತಿಳ್ಕೊಳ್ಳೋದು? ಏನದು? ಪಾಸ್ವರ್ಡ್ ನೋಡ ಪ್ರದೀಪ್. Awaiting the service of notice ಅಂತ ಹಿಂಗ್ ಬರೀರಿ. Notice to second respondent is not yet returned. Notice issued to second respondent not yet returned. Post after service of notice to second respondent. ನಾನೇನ್ ಮಾಡೋದು? ಬಂದಿದ್ರೆ ನಾನು ಇಮಿಡಿಯೇಟ್ಲಿ ಆರ್ಡರ್ ಮಾಡ್ತೀನಿ, ತಮಗೆ ಗೊತ್ತಿದೆ. ಅವ್ರನ್ನ ಕೇಳಿದಲ್ಲೇ ಮಾಡೋ ಹಾಗಿಲ್ಲ ಅಲ್ವಾ? ಅದಕ್ಕೆ ಹೋದ್ ಸತಿ ಎಲ್ಲ ಹೇಳಿದೀವಿ, ಎಲ್ಲ ಮಾಡಿದೀವಿ. ರಾಮನಗರದ ಒಂದ್ ಬಂತು, ಅದನ್ನ ಮಾಡಿದ್ವಿ. ಯಾವ್ದೋ ಹಾಸನ್ನು ಬಂದಿಲ್ಲ. All are interested only in elections, police. Nobody is interested in any other work. ಈಗ this is the scenario till the elections would complete. Entire police force is somehow interested in getting these elections through, and thereafterwards, depending upon the which party that comes into the power, get their necessary postings. Unfortunate situation. All right. Manjunath. ಯಾವ್ದಿದು? ಆಲ್ ರೈಟ್, ಅದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಲಿ, ನಿಧಾನಕ್ಕೆ ಹೋಗ್ಲಿ ಬಿಡಿ. ಆಯ್ತು, ಇವ್ರ ರಿಜೆಕ್ಟ್ ಮಾಡೋಣ ಬಿಡಿ. ನೋ ಇವ್ರಿಗೆಲ್ಲ ರಿಜೆಕ್ಟ್ ಮಾಡೋಣ ಬಿಡಿ. ಕಾಂತಿಭೂಷಣ್, ದೀಸ್ ಪೀಪಲ್ ಹ್ಯಾವ್ ಈಟನ್ ಅವೇ ದಿ ಬ್ಯಾಂಕ್ ಮನಿ. ಕೆಲಸ ಕೊಟ್ಟಿದ್ದಂತ ಬ್ಯಾಂಕ್ಗೆನೆ ನಾಮ ಹಾಕಿದ್ದಾರೆ ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು? ಇನ್ನೊಬ್ಬರದ್ದು ಏನಾಯ್ತದ? ಇನ್ನೊಬ್ಬರದ್ದು ವಜಾ ಮಾಡಿದೀವಿ ತಾನೆ? No, only that lady, because she was. All right, ಇದನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡೋದು. ಹಾ, ಹೇಳಿ. Yes, you. ಇವ್ರು ಯಾರು? ಪಲ್ಲವಿ ಅಂದ್ರೆ
she's accused number 3 based on her voluntary statement in that time she's arrested in this crime.
ದೀಪ್ತಿ ಯಾರು?
It is here accused number 2 with the dishonorable court has already granted bail.
Now where is that voluntary statement? Read it. Read it. One bar 2023. 1 bar 2023 is the present case. Which is the other case? Where do you get that? Whether she was arrested there?
She was arrested and she's granted bail there.
ಎಷ್ಟು ಮೋಸ ಮಾಡಿದ್ದಾರೆ ಹಂಗಾರೆ ಇವರು?
That is accused number 1. Urala is the contract employed for the HDFC.
ADBA.
The accused number 1 who was apart the someone who is 18 was she is granted bail, but in that crime, and she's not been arrested in this crime.
ಅವ್ರು ಯಾರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ ಇವ್ರಿಗೆ ಬೇಲ್ ತಗೊಳ್ಳಕ್ಕೆಲ್ಲ. See, one illegality cannot be made to suffer, become perpetuate by another illegality. Illegality cannot be perpetuated. That is the law. See, if you stand on your own, what is it that is available on against this lady in this case?
Absolutely nothing.
Then why are you arrested?
The arrest on 13 March 2023 is there in the custody for about 80 days, and she was taken to the police custody on 6/2/2023 to 11/2023.
What is it that it has come out from there? What is it that it has been elicited in that? 6/2. No, 6/2 when she was taken to custody, voluntary statement. What is it that has been recovered?
10 bonds have been recovered.
10
LIC bonds have been recovered. Some of that is to the worth of rupees 96
Where was it? Where was it? Why should it be in her custody?
Absolutely right, madam. Not happening.
Then why should she grant it? Why should be given?
Now nothing has to be recovered from her as of now.
No, being a contract employee, why she would take away the LIC bonds of somebody? No, you produce that, Mr. HGP seeks time to file necessary document to show the involvement of the petitioner in the incident. Urgent. ನಾಳೆ ನಿಮ್ ಪಾಲಿಸಿನೇ ತಗೊಂಡೋಗ್ಬಿಡ್ತಾಳೆ ಅವಳು ಬಿಟ್ರೆ
Then what is the other?
ಆಗ್ತಿಲ್ದೇರೆ ಎಷ್ಟೋ ಅನ್ಯಾಯ ಇಷ್ಟ ಆದ್ರೂ ಅನ್ಯಾಯನೇ ಅಲ್ವಾ ಮತ್ತೆ ಭೂಷಣ್ ಸಿ ಪಾಯಿಂಟ್ ಈಸ್ ನಾಟ್ ದಟ್. ಜನಸಾಮಾನ್ಯರು ಬ್ಯಾಂಕು ಮತ್ತು ಪೋಸ್ಟ್ ಆಫೀಸ್ ನ ನಂಬೋ ಉದ್ದೇಶ ಏನು ಅಂದ್ರೆ ಬೇರೆ ಕಡೆ ನಮ್ಗೆ ರಕ್ಷಣೆ ಇಲ್ಲ, ಹಾಗಾಗಿ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ ಪೋಸ್ಟ್ ಆಫೀಸ್ ನಲ್ಲಿ ದುಡ್ಡಿಟ್ರೆ ನಮ್ ಕ್ಷೇಮ ಕಷ್ಟ ಕಾಲಕ್ಕಾಗುತ್ತೆ ಅಂತ ಐಡಿಯಾ ಇರೋದವ್ರು. ಈಗ ಬೇಲಿನೇ ದ್ವಲಾಮೆ ಇದ್ರೆ ಕಾಂಟ್ರಾಕ್ಟ್ ಎಂಪ್ಲಾಯಿ ಇದೆಲ್ಲ ಮಾಡ್ಸೋದೇ ಹೀಗೆ. ಒನ್ ಡೇ ಇನ್ಚಾರ್ಜ್ ಬರ್ತಾರಲ್ಲ ಅವರು, ಮೊನ್ನೆ ಒಂದಲ್ಲಿ ಮಾಡಿದೀವಿ ನೋಡಿ, ಅಸಿಸ್ಟೆಂಟ್ ಮ್ಯಾನೇಜರು. ಏನು ಅದೇನು ₹1-2 ಅಲ್ಲ, ಕ್ಯಾಶ್ ಹೋಯ್ತು. ಅದ್ರ ಜೊತೆಗೆ 391 ಗೋಲ್ಡ್ ಪ್ಯಾಕೆಟ್ಸ್ ಅಂತೆ. ಅಂದ್ರೆ ಅವ್ರದ್ದು ಬ್ಯಾಂಗಲ್ಸು ಅವೆಲ್ಲ ಇಸ್ಕೊಂಡು ಗೋಲ್ಡ್ ಲೋನ್ ಅಂತ ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ, ಅದು ಹೊರಟೋಗಿದೆ. ಅಂಡ್ ಇದು ಸಿಂಪಲ್ ಥಿಂಗ್ ಈಸ್, ಮೇನ್ ಡೋರ್ ನ ಗ್ಯಾಸ್ ಕಟರ್ ನಲ್ಲಿ ಕಟ್ ಮಾಡಿದ್ದಾರೆ, ಐರನ್ ಸೇಫ್ ನ ಗ್ಯಾಸ್ ಕಟರ್ ಅಲ್ಲಿ ಕಟ್ ಮಾಡಿದ್ದಾರೆ. ಬೆಳಗ್ಗೆ ಯಾರೋ ಗ್ರಾಹಕರು ಹೋಗಿ ಹೇಳೋದಂತೆ, ಸೆಕ್ಯೂರಿಟಿ ಇಲ್ಲ, ಅದಕ್ಕೆ ಅಲಾರಂ ಇಲ್ಲ, CCTV ಇಲ್ಲ, ಥರ್ಮಲ್ ಅಲಾರಂ ಅಂತ ಹಾಕಿರ್ತಾರೆ. ಥರ್ಮಲ್ ಅಲಾರಂ ಅಂತಂದ್ರೆ ರೆಗ್ಯುಲರ್ ಅಲಾರಂ ನಲ್ಲಿ ಬರೇ ಫೋಟೋ ಸೆನ್ಸಿಟಿವ್ ಇರುತ್ತೆ. ಥರ್ಮಲ್ ಅಲಾರಂ ಅಲ್ಲಿ ಒಂದು ಟೆಂಪರೇಚರ್ ಇರುತ್ತೆ, ಆ ಟೆಂಪರೇಚರ್ ಸಂಬಂಧಪಟ್ಟ ಹಾಗೆ ವ್ಯತ್ಯಾಸ ಆಗುತ್ತೆ. ದಟ್ ಈಸ್ ಬೈ ಎನಿ ಹ್ಯೂಮನ್ ಬೀಯಿಂಗ್ ಆರ್ ಎನಿ ಅನಿಮಲ್ ಪಾಸಿಂಗ್ ಥ್ರೂ ದಟ್ ಪ್ಲೇಸ್. ಆ ಥರ್ಮಲ್ ಅಲಾರಂ ಅಲ್ಲಿ ಏನಾಗಿರುತ್ತೆ ಅಂದ್ರೆ, ಆ ಟೆಂಪರೇಚರ್ ಒಂದ್ ಚೂರ್ ವೇರಿಯೇಷನ್ ಆದ್ರೂ ಹೂಟರ್ ಓ ಅಂತ ಬಡ್ಕೊಳ್ಳುತ್ತೆ. ಏನಾಯ್ತು? ಎಸ್ಪೆಷಲಿ ಗೋಲ್ಡ್ ಆರ್ನಮೆಂಟ್ಸ್ ನ ನೀವು ಪ್ಲೆಡ್ಜ್ ಮಾಡಿಕೊಂಡು ಸಾಲ ಕೊಟ್ಟಿರುವಂತ ಸಂದರ್ಭದಲ್ಲಿ ಅದಕ್ಕೆ 5 ಲೇಯರ್ದು ಕಬ್ಬಿಣದ್ದನ್ನ ಐರನ್ ಸೇಫ್ ಹಾಕ್ಬೇಕು. ಈಚ್ ಒನ್ ಕನ್ಸಿಸ್ಟಿಂಗ್ ಆಫ್ ಎ ಪರ್ಟಿಕ್ಯುಲರ್ ಥಿಕ್ನೆಸ್ ಆಫ್ ದಿ ಮೆಟಲ್, which cannot be easily cut by any of these things. And if somebody meddles that, automatically hooter should shout. ಏನು ಆಗಿಲ್ಲ ಇದ್ರಲ್ಲಿ, 3 ಕೋಟಿ ಚಿಲ್ರೆ. ಈಗ ಅದು ಸಮ್ ಕೋಆಪರೇಟಿವ್ ಬ್ಯಾಂಕ್ ವಾಪಸ್ ಬರುತ್ತಾ? ಅದು ಖಂಡಿತ ಬರೋದಿಲ್ಲ. ಈಗ ನಾಳೆ ಬೆಳಗ್ಗೆ ಅವ್ನು ಯಾರೋ ಒಬ್ಬನ್ ದುಡ್ಡು ಕೊಟ್ಬಿಟ್ಟು ನಂದು ಗೋಲ್ಡ್ ವಾಪಸ್ ಕೊಡಿ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಅವರು, ಬ್ಯಾಂಕ್ ಅವರು? ಪ್ಲೀಸ್ ಟೆಲ್ ಮೀ. ಸೊ ಇದೆಲ್ಲ ಏನಾಗಿದೆ, ಇದೆಲ್ಲ ಅವ್ರ ಮನೆ ಕಳ್ರಿಲ್ದಲ್ನೇ ಇದೆಲ್ಲ ಹೊರಗಡೆ ಆಗಕ್ ಆಗೋದೇ ಇಲ್ಲ. ಅವತ್ತೇ ಈ ಮ್ಯಾನೇಜರ್ ರಜಾ, ಅವತ್ತೇ ಅಸಿಸ್ಟೆಂಟ್ ಮ್ಯಾನೇಜರು, ಅವತ್ತೇ ಸಾಯಂಕಾಲ, ಅವತ್ ಸಾಯಂಕಾಲನೇ ಮ್ಯಾನೇಜರ್ ಇಲ್ಲ ಅಂತ ಗೊತ್ತಿದೆ. ಯಾರು ಹೇಳ್ಬೇಕು ಇವೆಲ್ಲ? ಅವತ್ತೇ ಕಳ್ರು ಬಂದಾರೆ, ಲಾರಿಲ್ ಬಂದಿದ್ದಾರೆ ಕಳ್ರು. ಇವೆಲ್ಲ ಏನಾಗತ್ತೆ ಅಂತಂದ್ರೆ ಒಂದು ದಿನದ ಇದೆಲ್ಲ ಇದು. ಯಾರೋ ಬಂದ್ರು, ಏನೋ ಕಳ್ತನ ಮಾಡಿದ್ರು, ಮನೇಲಿ ಹೋದ್ರು, ನೋಡಿದ್ರು ಅನ್ನೋದಲ್ಲ. ಇಂಜಿನಿಯರ್ಡ್ ಕ್ರೈಮ್ಸ್ ಇವೆಲ್ಲ. ಆ ಇಂಜಿನಿಯರ್ಡ್ ಕ್ರೈಮ್ಸ್ ನಲ್ಲಿ ಒಳಗಡೆ ಇರೋರು ಸಾಥ್ ಕೊಡದೇ ಇದ್ರೆ ಇದೆಲ್ಲ ಆಗೋದೇ ಇಲ್ಲ. ಇವಾಗ ಬಾಂಡ್ ನ ಇವರು ಕಾಂಟ್ರಾಕ್ಟ್ ಎಂಪ್ಲಾಯಿ ತನ್ನ ಮನೆಗೆ ಇಟ್ಕೊಂಡಿದ್ದಾಳೆ 9 ಬಾಂಡು ವರ್ತ್ 96 lakhs, ಲಿಟಲ್ ಲೆಸ್ ದೆನ್ ಎ ಕ್ರೋರ್ ಅಂದ್ರೆ ವಾಟ್ ಇಸ್ ದಿ ಇಂಟೆನ್ಷನ್? ವಾಟ್ ಇಸ್ ದಿ ಇಂಟೆನ್ಷನ್? ಪ್ಲೀಸ್ ಟೆಲ್ ಮಿ. ನೋ ಯು ಆರ್ ಆಲ್ ನೋಡಿ, ನಾನು ಕೆಲವು ವಿಷಯಗಳಲ್ಲಿ ನಾನು ಅದಕ್ಕೆ ಹೇಳ್ತೀನಿ, ತಾವು ಹೇಳಿದ್ದಕ್ಕೆ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೀನಿ. ಫೇರ್ ಆಗಿ ತಾವು ಹೇಳಿದಿರಿ, ಅವ್ರು ಹಾಕ್ಲಿ. ಆ ಇನ್ನೊಬ್ರದ್ದು ಏನ್ ತಾಪತ್ರ ಇತ್ತು, ಪಾಪ ಗರ್ಭಿಣಿ, ಇನ್ನಲ್ಲಿ ಕೂತ್ಕೊಂಡು ಜೈಲಿನಲ್ಲಿ ಆರೈಕೆ ಇಲ್ಲ, ಮತ್ತೊಂದೇನೋ ಮಗ್ದೊಂದು ಆಗ್ಬಿಡ್ಬಾರ್ದು ಅನ್ನೋ ಒಂದು ಅಲ್ಲಿ ಬರ್ದಿದ್ದೀನಿ ಅದನ್ನ, ಓನ್ಲಿ ಆನ್ ದಟ್ ಗ್ರೌಂಡ್ ಅಂತ, ಬೇರೆ ಇನ್ನೇನು ಇಲ್ಲ. ಸೊ ಅದಕ್ಕೇನೋ ಅಯ್ಯೋ ಅಂದಿದ್ದಾಯ್ತು. ಇವಾಗೆಲ್ಲ ಏನಾಗಿದೆ, ಪಾಪದ ದುಡ್ಡಲ್ವಾ ಶಾಂತಿ ಅವ್ರೆ? ಮತ್ತೆ ಅವ್ರು ಯಾರೋ ಪಾಪ ಇಟ್ರೋ LIC ಬಾಂಡ್ ಇದ್ದು ಏನಾಗಬೇಕು? No, you are right. You are fair to the court. I am not saying anything there. ಅದಿಲ್ಲದೆ ಇದ್ರೂ ಕೂಡ ಅಲ್ಲಿ ಸಿಕ್ಕುತ್ತೆ ನಮ್ಗೆ ಪೊಲೀಸ್ ರೆಕಾರ್ಡ್ಸ್ ನಲ್ಲಿ. No, nothing more to recover ಅಲ್ಲ, ಕರೆಕ್ಟ್, ರಿಕವರ್ಡ್ ಆಯ್ತು. ಇನ್ನು ಎಷ್ಟು ಜನದ ಹತ್ರ ಎಷ್ಟು ಹೋಗಿದೆ ಅಲ್ವಾ? I have not seen that fellow, that chartered accountant walking with the rubber slippers, Hawaii chappals on the road. ಹೆಸರೇನೋ ಇತ್ತು, ಗುರುಮೂರ್ತಿ ಅಂತಲೋ ಏನೋ, some such fellow. ಆರ್ಡಿನರಿ ಎಲ್ಲೋ ಯಾವ್ದೋ ಚಾರ್ಟರ್ಡ್ ಅಕೌಂಟೆಂಟ್ ಆಫೀಸ್ ನಲ್ಲಿ ಅಸಿಸ್ಟೆಂಟ್ ಆಗಿದ್ದ, 100 ರೂಪಾಯಿ ತಕೊಂಡು ರಿಟರ್ನ್ ಫೈಲ್ ಮಾಡೋದು. ಒಂದ್ ಫೈನ್ ಡೇ ಅವನಿಗೆ ತಲೆಗೆ ಬಂದ್ಬಿಡ್ತು ಮೋಸ ಮಾಡೋದು ಹೆಂಗೆ ಅಂತ. He hired a very big space next to our senior counsel A.N. Jairam's office, somewhere there in that Unity buildings. Managing directors of the non-banking finance company to take appointment and stand in the queue to get the business from this fellow. Look at the scenario. And he used to give the appointment only to 2 or 3, wait for about an hour or two, chit-chatting with somebody in the ಯಾರು ಇಲ್ಲ, ಎಲ್ಲ ಬರೇ ಹೋಕ್ಸ್ ಕಾಲ್ಸ್ ಟು ಮೇಕ್ ಇಟ್ ಅಪಿಯರ್ ದಟ್ he is so busy. ಪ್ಯಾರಾಫೆರ್ನೇಲಿಯಾ ಎಲ್ಲ ಹಂಗೆ ಸೆಟ್ ಮಾಡಿದ್ರು. ಬರೇ 1% ಕಮಿಷನ್ ಫಾರ್ ಗೆಟಿಂಗ್ ಎ ಬಿಸ್ನೆಸ್ ಫ್ರಮ್ X to Y. 1% ಕಮಿಷನ್ used to charge. ಅವನದೊಂದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆ ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ರೈಡ್ ಆದಾಗ. ಅದ್ರೊಳಗಡೆ ಒಂದ್ ಕಂಪನಿ ಹೆಸರೇನ್ ಗೊತ್ತೇನು? ಇವನ್ ಕೊಡ್ಸಿರೋದ್ ಸಾಲನ, ಇವನ್ ರೆಕಮೆಂಡ್ ಮಾಡಿ ಅವ್ರು ಯಾರೋ ಕೊಟ್ಟಿರೋದ್ ಸಾಲನ, ಎಸೆಂಡಾ, ಲಾಯ್ಡ್ಸ್ ಇವರೆಲ್ಲ ಕೊಟ್ಟಿದ್ರು. Do you know what is the name of the company? Beautiful synonym. Blades India Limited. What a beautiful name, you see. ಒಂದು, ಐ ಆಮ್ ಸಾರಿ ಟು ಸೇ, ವೆರಿ ಹೈಯೆಸ್ಟ್ ಪೊಸಿಷನ್ ಅಲ್ಲಿ ಇಂಡಿಯನ್ ಇದ್ರೊಳಗಡೆಗೆ ಇದ್ದಂತವ್ರ ಮೊಮ್ಮಗ ಅವನು. ಹೆಸರೆಲ್ಲ ಯಾಕೆ ಸುಮ್ನೆ ಪಾಪ, ಅವರೆಲ್ಲ ಆಗೋಗಿದ್ದಾರೆ. ಅವ್ರ ಮೊಮ್ಮಗ, ಅವನ ಕಂಪನಿ ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್, ರಾಜಾಜಿನಗರ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟೌನ್ ಅಲ್ಲಿ ಅಂತ. ಅವರು ಪಾಪ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ ದುಡ್ಡು, ಇಲ್ಲೂ ಏನು ಇಲ್ಲ. ನಾನು ಅದ್ರದ್ದು ಸೈಜ್ ಆಫ್ ದಿ ಎಕ್ವಿಪ್ಮೆಂಟ್ ನೋಡಿದ್ರೆ ಒಂದು 2 ಎಕರೆ ಜಮೀನ್ ಬೇಕಾಗುತ್ತೆ ಅದನ್ನ ಇನ್ಸ್ಟಾಲ್ ಮಾಡ್ಲಿಕ್ಕೆ. ಇವ್ರು ಕೊಟ್ಟಿರ್ತಕ್ಕಂಥ ಸೈಜ್ ಇರ್ತಕ್ಕಂಥ ಎಕ್ವಿಪ್ಮೆಂಟ್ ನ ಕಳಿಸ್ತೀವಿ ನಾವು, ಹೋಗಿ ನೋಡ್ಕೊಂಬ ಹೋಗು ಅಂತ ನಮ್ಮ ಇವ್ರಿಗೆ ಟೀಮ್ಗೆ. ಹೋದ್ರು ಅವರು, ಎಷ್ಟಿದ್ಯಪ್ಪ ಅಂತ. ಸರ್ ಒಂದು ಎಸ್ಟಾಬ್ಲಿಷ್ಮೆಂಟ್ ಏನೋ ಇದೆ, ಎಲ್ಲಾ ಸೇರಿದ್ರು ಒಂದು 100 by 150 ಆಗಲ್ಲ, ಇನ್ಕ್ಲೂಡಿಂಗ್ ದಿ ಸೆಕ್ಯೂರಿಟಿ ಪೋಸ್ಟ್ ಅಷ್ಟೇ ಇರೋದು. ನಾನು ಮೊದ್ಲೇ ಅವ್ನ್ಗೆ ಹೇಳಿದ್ರೆ ಏನಿರುತ್ತೆ ನೋಡ್ಕೊಂಬ ಅಂದ್ರೆ, ಅವ್ನು 2 ಎಕರೆ ಇದೆ ಅಂತ ಬರ್ಬಿಡೋನು. ಅದಕ್ಕೆ ಫಸ್ಟ್ ಹೋಗಿ ಎಷ್ಟಿದೆ ಸೈಜ್ ಅವ್ರದ್ದು ನೋಡ್ಕೊಂಬ ಅಂತ ಅಷ್ಟೇ ಕೇಳಿದೆ. ಈ ಎಕ್ವಿಪ್ಮೆಂಟ್ ಇದೆಯಾ ಅಂತ ಕೇಳೋದ್ ಬೇಡ. ನೋಡ್ಕೊಂಡ್ ಬಂದಾದ್ಮೇಲೆ ಐ ಸಿಂಪ್ಲಿ ಫೈಲ್ಡ್ ಎ ಸೂಟ್ ಫಾರ್ ರಿಕವರಿ ಆಫ್ ದಟ್ ರಿಪೊಸಿಷನ್ ಆಫ್ ದಟ್ ಎಕ್ವಿಪ್ಮೆಂಟ್. ಅಪಾಯಿಂಟೆಡ್ ಎ ಕೌನ್ಸಿಲ್ ಲೈಕ್ ಅವರ್ ಫ್ರೆಂಡ್ ಮಂಜುನಾಥ್. ಕೋರ್ಟ್ನವ್ರು ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರು. ಮಂಜುನಾಥ್ ಹೋಗಿ ಈ ಜಾಗ ನೋಡ್ಕೊಂಡ್ ಬಂದು ಅದಿದೆಯಾ ಇಲ್ವಾ ಹೇಳಿ ಅಂತ. ಮಂಜುನಾಥ್ ಹೋದ್ರು, ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಬರೆದ್ರು. 409 ಜಡದ್ ಬಿಟ್ಬಿಟ್ವಿ, ಮುಗಿದೋಯ್ತು ಅಲ್ಲಿಗೆ. ಎಲ್ಲದಕ್ಕೂ ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆಯಲ್ಲ, ಬ್ಯಾಂಕ್ ಅವ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ, ಬ್ಯಾಂಕ್ ಅವ್ನು ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡಿದಾನೆ, ಹೌದು ಅಲ್ಲಿ ಇನ್ಸ್ಟಾಲೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇದೆ, ಲಾರಿ ರೆಸಿಟ್ ಇದೆ, ಮೂವ್ಮೆಂಟ್ಗೆಲ್ಲ ಇದೆ, ಸಿ ಫಾರಮ್ಸ್ ಇದೆ. ಇದು ಬಾವಿ ಕಳೆದಿದೆ, ಹಿಂದೆ ಒಂದು ಬಾವಿ ಕಳೆದಿದೆ ಅಂತ ನಾಟಕ ಬಂದಿತ್ತಲ್ಲ, ಅದೇ ತರದ್ದೇ ಇದು. ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಮೇಲಿದೆ, ಕೊಡಿ ಅಂತ ಹಿಡ್ದಾಕ್ಬಿಟ್ಟು. I think my client is the only person who could recover the money from that fellow, none else. ಅವನ್ಗೆ ನೋಡಿ ಅದೇ ಮುಳುವಾಯ್ತು. ಶಿಶುಪಾಲಂಗೆ 101ನೇ ಪಾಪಕ್ಕೆ ಕಾಯ್ತಾ ಇದ್ನಲ್ಲ ಕೃಷ್ಣ, ಹಂಗೆ ಬ್ಲೇಡ್ಸ್ ಇಂಡಿಯಾ ಅದೇ ಮುಳುವಾಯ್ತು. ಅವ್ನು IT ರೈಡ್ ಆಯ್ತು, ತಾಪತ್ರಯ ಆಯ್ತು, ಡಾಕ್ಯುಮೆಂಟ್ ಸಿಕ್ತು, ಎಲ್ಲ ಆಯ್ತು, ಬೀದಿಗೆ ಬಿದ್ಬಿಟ್ಟ. ಅದೇ ಯೂನಿಟಿ ಬಿಲ್ಡಿಂಗ್ ಮುಂದೆ ಹವಾಯಿ ಚಪ್ಪಲಿ ಹಾಕೊಂಡು ಅರ್ಕಲ್ ಶರ್ಟ್ ಹಾಕೊಂಡು ಓಡೋದ ಸ್ಥಿತಿ ಬಂದ್ಬಿಡ್ತು. ಅಲ್ಲಿ ಸತ್ಯಂ ರಾಜು ಅಂತ ಆಯ್ತಲ್ಲ ಆಂಧ್ರದಲ್ಲಿ, ಸೇಮ್ ವೇ. ಇವೆಲ್ಲ ವಿಪರೀತ ಆಂಬಿಷನ್ಸು. ಇರ್ಲಿ, ಒಂದು ಲೆವೆಲ್ ತನಕ ಇಟ್ಕೊಳ್ಳಿ, ಏನೋ ಮಾಡ್ಲಿ, ನ್ಯಾಯಯುತವಾಗಿ ಎಂಟಾಣಿ ಸಂಪಾದನೆ ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಈ ತರ ಮೋಸ ಮಾಡಿದ್ರೆ ಯಾರ್ ದುಡ್ಡು ಸರ್? ಇವತ್ತಿನ ದಿವಸ ಆ ಯಾರು ಇವ್ರಿಗೆಲ್ಲ ಈ ತರದವ್ರಿಗೆಲ್ಲ ಸಾಲ ಕೊಟ್ಟು ಆ ಕಂಪನಿಗಳೇ ಮುಳುಗೋದ್ವು ಇವತ್ತು. ದೇ ಹ್ಯಾಡ್ ಟು ಫೇಸ್ ದಿ winding up proceedings before this court, and this court ordered winding up of those companies. For whose fault? ಅದರಿಂದ ಕ್ರೈಮ್ಗೆ ಕರುಣೆ ಕಕ್ಲಾತಿ ಇಲ್ಲ. ಅಂತಕನ್ನ ದೂತರಿಗೆ ಕಿಂಚಿತ್ತು ದಯವಿಲ್ಲ ಅಂತ ಒಂದು ದಾಸ ಸಾಹಿತ್ಯದ ಹಾಡು. ಅಂತಕ ಅಂದ್ರೆ ಯಮ, ಏಜೆಂಟ್ಸ್ ಆಫ್ ಯಮ ಹ್ಯಾವ್ ನೋ ಮರ್ಸಿ ಅಂತ ಮೀನಿಂಗ್ ಆಫ್ ದಟ್ ಸಾಂಗ್. ನಾವು ಕ್ರಿಮಿನಲ್ ಕೇಸಸ್ ಇಟ್ಕೊಳ್ಳುವಾಗ ಆ ಮೆಂಟಾಲಿಟಿ ಇಟ್ಕೋಬೇಕು, ಇಲ್ದಿದ್ರೆ ಬಹಳ ಕಷ್ಟ. People at large, people at the, no, see, IDBI, they have to now make a provision for these losses. Their the profit rate will come down because they make provision. Their rating will come down. As a result, the people will start withdrawing the money from there. Where do they get? It is putting the buzzer on the panic button, no? Now what will happen? So far reaching effects irutte. Iವ್ರು ಮಾಡೋದು ಇವ್ರು ಯಾರೋ 4 ಅಣಿಗೋ 8 ಅಣಿಗೋ ಕಾಂಟ್ರಾಕ್ಟ್ ಎಂಪ್ಲಾಯಿನೋ ಮತ್ತೊಂದು ಮಾಡೋದು ಮಾಡ್ಬಿಟ್ರೆ ಅದಕ್ಕಾಗೇನೆ ಬಹಳ ಕಷ್ಟ, ಬಹಳ ಕಷ್ಟ. ಹಾಗಾಗಿ one must see all these things little behind what is happening. Okay, 439 ಕೇಸು, ಕಂಪ್ಲೇಂಟು, ತಾವು ಹೇಳಿದ್ದು ನಾನು ಕೇಳಿದ್ದು ಜನರಲ್ ಆಗಿ ಆಗ್ಬಿಡ್ಬಾರ್ದು, ಮೆಕ್ಯಾನಿಕಲ್ ಆಗಿ. Court must, while passing the orders, must look into these aspects as well, because it will have a direct impact on the society. While we talk of the right of an accused, we cannot forget the right of the people who have lost the money for no fault of them. Depositing the amount in the bank itself, is it a sin? Taking the loan by pledging the LIC policy, is it a sin? Tomorrow that fellow dies. Idr mele iವರು ಇದನ್ನ ತಗೊಂಡೋಗಿ ಇನ್ನೆಲ್ಲೋ ಇಟ್ಬಿಟ್ಟಿರ್ತಾರೆ. ನಾಳೆ ಬೆಳಗ್ಗೆ ಬಂದ್ರೆ ನನಗೆ ಗೊತ್ತಿಲ್ಲ, ಕಾಂಟ್ರಾಕ್ಟ್ ಎಂಪ್ಲಾಯಿ ಎಲ್ಲ ಪಲ್ಲವಿ ಮೇಲೆ ಹಾಕ್ಬಿಟ್ಟು ಕೈ ತೊಳ್ಕೊಂಡ್ಬಿಟ್ರೆ ಪಲ್ಲವಿ ಇಸ್ ಅಬ್ಸ್ಕಾಂಡಿಂಗ್. ಇದು ಇವತ್ತಿಂದಲ್ಲ. ನೀವು ಮೊನ್ನೆ ಯಾವ್ದೋ ವಾಟರ್ದು ಒಂದು ಮಾಡಿದ್ವಿ ನಾವು BWSSP ನಲ್ಲಿ. 700 ರೂಪಾಯಿ, 800 ರೂಪಾಯಿ, 300 ರೂಪಾಯಿ ಇಂಥದ್ನೆಲ್ಲ ತಕೊಂಡು 6 ಲಕ್ಷ ಚಿಲ್ಲರೆ ಟೋಪಿ ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾನೆ. ಎಷ್ಟು ಜನಕ್ಕೆ ಟೋಪಿ ಹಾಕಿರ್ಬೇಕು ಅವನು? So therefore, such of the things cannot be tolerated. While we are there, fine, ಅದೇನು ಅಂತ ಇದಾಗಲ್ಲ, ಏನೋ ಕೊಡ್ತಾರೆ, ಶಿಕ್ಷೆ ಪ್ರಮಾಣ ಎಲ್ಲ ಲೆಕ್ಕ ಮಾಡ್ಕೊಂಡ್ರೆ ಕಡಿಮೆ ಆಗತ್ತೆ, ಎಲ್ಲ ಆಗತ್ತೆ. But people should realize, people like whoever who joins the contract, now she loses the job. Please understand, look at the scenario. ಏನ್ ಕಷ್ಟ ಇದೆಯೋ ಮನೆಯಲ್ಲಿ. ಕಾಂಟ್ರಾಕ್ಟ್ ಎಂಪ್ಲಾಯಿ ಅಂತ ಸೇರ್ಕೊಂಡಿದ್ದಾರೆ, ಇವಾಗ ಕ್ರಿಮಿನಲ್ ಕೇಸಿಗೆ ಸಿಕ್ಕಾಕೊಂಡ್ಬಿಟ್ರು. ಮದ್ವೆ ಆಗಿದ್ರೆ ಗಂಡ ಅನುಮಾನವಾಗಿ ನೋಡ್ತಾರೆ, ಮಕ್ಕಳಾಗಿದ್ರೆ ಸ್ಕೂಲಲ್ಲಿ ಕೇಳ್ತಾರೆ ನಿಮ್ಮಮ್ಮನ ಯಾಕೆ ಜೈಲ್ಗೆ ಹಾಕಿದ್ರು ಅಂತ. ಏನ್ ಹೇಳುತ್ತವೆ ಮಕ್ಕಳು? ಅಕ್ಕಪಕ್ಕದಲ್ಲಿ ಇರಕ್ಕಾಗಲ್ಲ. ಓ ಇವಳು ಊರಿಗೆಲ್ಲ ಟೊಪ್ಪಿ ಹಾಕೊಂಡ್ ಬಂದಿದ್ದಾಳೆ ಅಂತ ಶುರು ಆಗುತ್ತೆ. See, they have to leave their establishment, ಬೇರೆ ಕಡೆ ಎಲ್ಲ ಹೋಗ್ಬೇಕು, ಏನೇನೋ ಮಾಡ್ಕೊಳ್ಬೇಕು, ಕೇಳ್ಬೇಕು, ಮಾಡ್ಬೇಕು. Lot of ramifications are there. ಅದೆಲ್ಲ ಗಮನಕ್ಕೆ ಇಟ್ಕೋಬೇಕಾಗತ್ತೆ. ಒಂದ್ ಕಾಲದಲ್ಲಿ ನಾವು ಧೈರ್ಯವಾಗಿ ಹೇಳ್ತಿದ್ವಿ, ಶಾಂತಿಭೂಷಣ್ ಅಪ್ಪ ಯಾರು ಸಿಸ್ಟರ್ಸ್ ಇದ್ರೆ ಅವರೆಲ್ಲಾರು ನಮ್ಮನ್ನು ಕ್ಷಮಿಸ್ಬೇಕು, ಹೆಂಗಸರು ಬಹಳ ಪ್ರಾಮಾಣಿಕರು ಅಂತ. ಈಗೆಲ್ಲ ಹೇಳೋದು, ಬರೋರೆಲ್ಲ ಹೆಂಗಸರೇ ಇದ್ದಾರಲ್ಲ ಅಪ್ರಾಮಾಣಿಕರು. ಹಾಗಾಗ್ಬಿಟ್ಟಿದೆ. ಸೊ ಪ್ರಾಮಾಣಿಕತೆ ಅಥವಾ ಅಪ್ರಾಮಾಣಿಕತೆ ಅಥವಾ ಇನ್ನೊಂದು ಮತ್ತೊಂದು ಯಾವ್ದನ್ನು ಒಂದು ನಾವು ಜೆಂಡರ್ ಬೇಸ್ಡ್ ಆಗಿ ತಿಳ್ಕೊಳಕ್ ಆಗಲ್ಲ. ಗಾನ್ ಆರ್ ದೋಸ್ ಡೇಸ್, ಲೇಡೀಸ್ ಇದಾರಪ್ಪ ಪರವಾಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಧೈರ್ಯವಾಗಿರೋರು. ನೋ, Now you see what is happening. Day in and day out, they are the accused persons. Active collusion. Even the first accused, ಅವರು ಕೂಡ ಲೇಡಿನೇ. Main accused, ಅಡ್ನೆಂಟ್ ಕೋಟಿ ಟೋಪಿ ಹಾಕ್ತಾರೆ. ಸುಚೆಲ್ಲನೋ ಏನೋ ಇದೆಯಲ್ಲ. Says. We look into it soon after the vacation, whatever that happens. All right. Call next case, ma. Yes, Mr. Objections. What is this matter? ಏನಾಯ್ತು? ಏನ್ ಅಫೆನ್ಸ್ ಇವ್ರೆ? ಏನ್ ರಿಕವರ್ ಇದೆ ನಿಮ್ಮ ಹತ್ರ? Everybody says nothing is recovered, but when you see the case, you will come to know. Where is your voluntary statement? Why have you not filed it? Sir? File misplace ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ? ಸಿಗುತ್ತಾ? ಇವತ್ತೇ ಸಿಗುತ್ತಾ? 12:30 1 ಗಂಟೆ ಒಳಗಡೆ. Because the court is rising little early today because of the farewell function of Honorable Justice Desai. I will not do any of those things. Counsel for the petitioner seeks time stating that the file is misplaced. In the meantime, the HGP seeks time to file objections. List matter urgent. Yes, Mr. Huh? Yes, too. 2,000 pieces worth 53 lakhs. ಮತ್ತೆ that's the other side file objections. HGP seeks time to file objections. Urgent. Yes, Mr. Patil. Yes, please. Are you filing the objections or orally opposing? What do you do? Yes. Ma. Or ಕಳಿಸಿ ಎಷ್ಟಿದ್ರಲ್ಲಿ ರಿಕವರಿ? Wait money 25,000. ಅದೊಂದು ಚೀಟಿ ಹಾಕ್ಬಿಟ್ಟು ಕಳಿಸಿ. Serial number 26. ಅದರಲ್ಲಿ 26 ಅಲ್ಲಿ wait money is 7,000 rupees. ಒಂದು ಚೀಟಿ ಹಾಕಿ ಕಳಿಸಿ. Yes. ಏನಾಗ್ತೀರಿ? Yes. Memo with documents filed. ರಿಕವರಿ ಎಲ್ಲ ಆಗಿದೆ ತಾನೆ? ಸಸ್ಪೆಂಡ್ ಆಗಿದ್ದಾರೆ ತಾನೆ? ಇನ್ನೂ ಒಂದಿದೆ, ಅದನ್ನು ಕರೆದ್ಬಿಡ ಅವ್ರು ಇರುವಾಗ್ಲೇ ನಾನು. ಯಾವ್ದದು? ಅಥವಾ ಇರ್ತಿರಲ್ಲ? ಇದೆ. ಓಕೆ. Yes, Mr. Leelesh Krishna. What is this matter, sir? What is the offense? What is the recovery? What are you in the society? ಅದೇನೋ ಲಲಿತಾ ಜ್ಯುವೆಲ್ಲರ್ಸ್ ಪಾರ್ಟ್ನರಾ? ಇಲ್ಲ ತಾನೆ? No, what is your avocation in the society? What do you do for your livelihood?
The allegation against me is that I have robbery. And if you remember one night who have committed this robbery.
Wait, read the complaint. ಯಾವಾಗಿಂದ ಇದ್ದೀರಿ ನೀವು ಕಸ್ಟಡಿಲಿ? Charge sheet filed. Where is the charge sheet material? Let the other side file objections. To file objections. Charge sheet ಆಗಿದೆಯಲ್ಲ ನೋಡಿ. What about the? Yes, Mr. Charge sheet ಆಗಿದೆಯಲ್ಲ. Any antecedents? Yes, heard Sri Leelesh Krishna and Leonard HGP. Petition under section 439 CRPC with the following prayer. Brief facts of the case are as under. The case came to be filed, a complaint came to be lodged by Sumati Naik with Mudvidre Police Station on 12/8/2021. It was registered in PAN number 255/2021 for the offence punishable under section 450 and 395 IPC. List of the complaint government revealed that on 12/8/2021 at about 8:20 p.m. when the complainant was watching the TV, two persons masked their faces, illegally entered into the house of the complainant and put the complainant under the fear by showing the deadly weapons and snatched the mobile telephone first and mobile telephone and a gold chain first next. Complainant raised alarm and the persons who had snatched the aforesaid articles ran away and disappeared in the dark. After registering the case against unknown persons, in crime number 255 of 2021, police conducted the detailed investigation and was able to apprehend the petitioner and two more accused persons. First, petitioner was arrested on 15th February 2021, 15th December 2021, and based on the voluntary statement, gold chain is recovered. First, after thorough investigation, charge sheet is also filed. Charge sheet. Next, attempt made by the petitioner to obtain an order of grant of bail is turned down by the learned district judge by order dated 28 July 2022. Thereafter, in SC number 66 of 22, thereafter petitioner is before this court. Next, learned counsel for the petitioner contended that petitioner is a handicapped person and his left hand is completely amputated and right leg is amputated below the knee level, and therefore, he could not have been the person who entered the house of the complainant on the alleged date of incident and robbed the aforesaid articles. First, at the most, the petitioner could be held liable for held liable for the offence of receiver of stolen property. First, ಅವ ಹೆಂಗ್ ಓಡಾಡ್ತಾನೆ? ಈಗ ಕಾಲಿಲ್ದೇ ಇದ್ದವನು ಓಡೋಗಕ್ಕಾಗಲ್ಲ. ಇನ್ನಿಬ್ರು ಇದಾರೆ, ಅವರಿಬ್ರು ಬೇಲ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಅವರಿಬ್ರು ತಗೊಂಬಂದ್ ಇವ್ರ ಹತ್ರ ಇಟ್ಟಿರ್ಬೇಕು. ಕಾಲಿಲ್ವಲ್ಲ ಸ್ವಾಮಿ ನಿಮ್ ಪ್ರಕಾರ? ಅದೇ ಪೆಟಿಷನರ್ ಪ್ರಕಾರ ಅವ್ರ ಆರ್ಗ್ಯುಮೆಂಟೇ ಹೇಳ್ತಿರೋದು ನಾವು ಅದನ್ನ. ಈಸ್ ನಾಟ್ ಹ್ಯಾವಿಂಗ್ ಎ ಪ್ರಾಪರ್ ಇದು, ಲೆಗ್ ಇಲ್ಲ, ಕೈ ಇಲ್ಲ, ನಾನೇನ್ ಮಾಡಕ್ಕಲ್ಲ ಅಂತ. ನಿಮ್ ಪ್ರಕಾರ ಅವರು ಬಂದಿದ್ದಿದ್ರೆ ಅವರಲ್ಲಿ ಸಿಕ್ಕಾಕೋಬೇಕಲ್ಲ. ಏನಾಯ್ತಮ್ಮ? ರಿಸೀವರ್ ಆಫ್ ಸ್ಟೋಲನ್ ಪ್ರಾಪರ್ಟಿ ಅಂಡ್ sought for grant of bail. First, per control and HGP opposes the bail petition, stating that recovery of the gold chain from the custody of the petitioner and a non-explanation. There are non properly and not offering the proper explanation with regard to the possession of the gold chain, which was robbed from the house of the complainant, establishes direct nexus between the incident and the petitioner and sought for rejection of the bail petition. First, next para. In the rival contentions, this court perused the material on record meticulously. On such perusal, it is seen that the present petitioner is physically handicapped, and the same is not in dispute. Whether at all the petitioner was also a party to the alleged robbery or not cannot be decided by this court at this stage by holding a mini trial, as the same may prevail in the case of the parties during the trial one way or the other. However, next para. However, the material on record also discloses that there is a recovery of gold chain from the custody of the petitioner, which was identified by the complainant. First, how the present petitioner came into the possession of the said gold chain is a matter that has to be adjudicated by the court after the full-fledged trial. First, suffice to say that the accused is in custody on and from 15/12/2021, and in the absence of any criminal antecedents, and also taking criminal antecedents, and also taking note of the fact that the charge sheet is filed, continuation of the accused petitioner in judicial custody is no longer warranted. Further, the co-accused persons have also been granted bail, which is not in dispute. Hence, following order, petition allowed, petitioner is directed to be enlarged on bail by taking a bond in a sum of rupees 1 lakh with 2 sureties for the like sum to the satisfaction of the trial court. Petitioner shall not indulge in similar offences. Petitioner shall attend the court regularly. Petitioner shall not tamper the prosecution witnesses in any manner. Petitioner shall not leave the jurisdiction of Mudbidre andre Udupina Mangalore district without prior permission. Violation of any one of the conditions once. Yes, Mr. Amar. ಮುಂದೇನು ಸಿಕ್ತಾ 3 ಕಾರು, ರಿಮೈನಿಂಗ್ ಕಾರ್ಸ್? ಕೇಳಿದ ಪ್ರಶ್ನೆಗೆ ನೇರವಾದ ಉತ್ತರ ಸಿಕ್ತಾ ಇಲ್ವಾ ಕೊಡಿ. ಸಿಕ್ತಾ ಅಂತಂದ್ರೆ ಸಿಕ್ತು ಅಂತ ಹೇಳ್ಬೇಕು, ಇಲ್ಲ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕು. ಅದ್ ಬಿಟ್ಬಿಟ್ಟು ಸುಮ್ನೆ ಸುತ್ತಿ ಬಳಸಿ ಉತ್ತರ ಕೊಟ್ರೆ. ಮೆಮೋ ವಿತ್ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ of accused number 1 in crime number 353/2022 filed. Third HGP copy furnished to HGP. HGP seeks to verify and submit. Post case stands adjourned. ಏನ್ ಅಫೆನ್ಸ್ ಅಮ್ಮ? ಏನ್ ಸಿಕ್ಕಿದೆ ನಿಮ್ಮ ಹತ್ರದಿಂದ? ಏನ್ ಸಿಕ್ಕಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಟೈಮ್ ಕೊಡೋಣ. ನಿಮ್ ಕಕ್ಷಿಗಾರರು ಜೈಲಲ್ಲಿ ಇದ್ದಾರೆ, ನಿಮ್ ಸೀನಿಯರ್ ಊರ್ಗ್ ಹೋಗ್ಬಿಟ್ಟಿದ್ದಾರೆ, ಅವನ್ ಅಲ್ಲೇ ಕೊಳಿತಾ ಇರ್ಬೇಕು. ಇವತ್ತೇ ಲಾಸ್ಟ್ ವರ್ಕಿಂಗ್ ಡೇ, ನಿಮಗ್ ಟೈಮ್ ಬೇಕಾಗಿದೆ, ಕೊಡೋಣ. ರಿಕವರಿ ಏನು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಫೈಲ್ ತಂದಿಲ್ಲ, ಓದಲ್ಲ, ಸೀನಿಯರ್ ಹೇಳಿರೋದು ಬರೇ ಟೈಮ್ ಕೇಳು ಅಂತ ಅಷ್ಟೇ ಮಾತ್ರ ಮಾಡೋದು. ಮಿಕ್ಕಿದ್ದೇನು ನನ್ ಕೇಳ್ಬೇಡಿ. ಕೊಟ್ರೆ ಕೊಡಿ, ಇಲ್ಲರ ವಜಾ ಮಾಡಿ. ಇದೇ ನಾನ್ ತಮ್ಮ ಸಬ್ಮಿಷನ್ನು. ಮತ್ತೆ ಹೆಂಗಾರು ಮಾಡ್ಕೊಡಿ. Mesreno. The so and so seeks time on behalf of N. Chandrana. Release this matter after vacation. Yes, Manjunatha. ಏನದು ಅಫೆನ್ಸ್ ಏನು HGP seeks time to file objections. Counsel for petitioner absent post after vacation. ಲಾರಿ ತಾನೆ ಅಫೆನ್ಸ್ ಏನು ಹೇಳಿ ಏನು ವಾಟ್ ಈಸ್ ದಿ ಫ್ರಾಡ್ ಹ್ಮ್ 14 let him appear, no? Heard Sri Gopal Singh and led HGP. Pursuant to section 438 CRPC, the following prayer. Brief facts of the case are as under. Sri Nilesh Kotari lodged a complaint with Commercial Street Police Station on 8th February 2023. It was registered in crime number 12/2023 for the offence punishable under section 420 IPC. Gist of the complaint governments reveal that the complainant is native of Rajasthan state and about 35 years earlier, he came back to Bangalore and settled here for the business purpose. First, on 1/2/2023, there was a mobile telephone call from mobile telephone bearing number 7676568684 and wanted to purchase 14 gold chains. First, on based on the same command 2/2/2023 at about 3:45 p.m. The complainant was required to meet the said person near Commercial Street in front of Krishna Diamond shop, Krishna Diamond shop, and said person took 14 gold chains weighing about 468 grams and handed over a gold biscuit weighing 500 grams. First time. When the said gold biscuit was tested later, it appeared to be a fake one. Based on such complaint, police registered a case against unknown person at the first instance and apprehended Yara the accused number 1, Sri Pawan Das. First, based on the voluntary statement given by Sri Pawan Das, present accused has been arraigned in the case and police are trying to apprehend him. Nekpara. Flag counsel for the petitioner approached the district court for grant of bail and the same is rejected by order dated 13th March 2023 in semis number 25/197 of 2023. First, thereafter petitioner is before this court. Next para. Reiterating the grounds set in the petition, Sri Gopal Das, that counsel for the petitioner vehemently contended, Gopal Singh vehemently contended that the petitioner is totally innocent of the offences alleged against him and only on the basis of the voluntary statement given by the accused number 1 Pawan Das, he has been falsely implicated in the case and sought for grant of anticipated bail. Per control and HGP opposes the bail grounds. First, next para. The material on record meticulously knew the rival contested parties On such perusal of the material on record, it is seen that the case came to be registered against a unknown person. First, the police were able to apprehend one Pawan Das, and based on his voluntary statement, present accused has been arraigned as accused number 2 in the case. First, whether at all present petitioner is involved in the alleged cheating or not cannot be decided by this court at this stage by holding a mini trial. It is for the investigation agency to investigate the matter and file appropriate report as is contemplated under section 174 of CRPC, 172 of the CRPC. First, next paragraph. Suffice to say that since the petitioner is not available to the investigation agency, directing the petitioner to join the investigation and undergo limited period of custodial interrogation would meet the ends of justice. Accordingly, following order. 28ನೇ ತಾರೀಕು ಇದೆಲ್ಲ ಇದೆಯಲ್ಲ ಮಾಡ್ಕೊತಿರಲ್ಲ ಹೇಳ್ಬೇಕಾ 28th ಗೆ you appear at 10 o'clock 7 p.m. 10 to 7. Thereafter enlarge him on bail for 1 lakh of rupees from yes. ಮೂರು ಲಕ್ಷ ರಾಕ್ಲಿ ಬಿಡಿ All right, our objections it requires consideration. Objections. HGP place time. Release this matter. ನಾನು ಹಿಂಗೆ ಹೇಳಕ್ಕಾಗತ್ತೆ ಅರ್ಜೆಂಟ್ ಅಷ್ಟೇ. Yes, Mr.
Please, Your Lordship. Sorry, my lord, I could not be present.
Talk, it's okay. ಏನಾಯ್ತು objection?
Please.
Pass over. ಅವ್ರು ಬರ್ಲಿ ಅವರು ಕನ್ಸರ್ನ್ HGP ಬರ್ಲಿ.
Yes, my lord, it is. Please, Your Lordship.
Over.
Read the complaint. Objection ಹಾಕ್ಲಿ ಬಿಡಿ ಅವರು. Objection ಹಾಕ್ಲಿ. CGP seeks time to file objections. Urgent. Offense of ಎಷ್ಟು kg? All right, HGP seeks time to file objections. HGP files objections. Counsel for petitioner pays time. Urgent. After vacation. ಅಲ್ಲ ಅದನ್ನ ಕೊಟ್ಟ ಮೇಲೆ ನಾವು ಬರೋಣ. All right, urgent after vacation. Latif. Objection ಹಾಕ್ಲಿ. Injury ಏನು? Have you got the wound certificate? ಅಲ್ಲ have you got the wound certificate? ಅವ್ರ objection ಹಾಕಿದ್ದಾರೆ ನಾನು ನೋಡಿದೀನಿ. ಅದರ ಒಳಗೆ ಅವರು ಸೀರಿಯಸ್ ಆಗಿ ಅಪೋಸ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. FIR ಇಂದ ಇಂಡಿಕೇಟ್ ಮಾಡದ ನೀವು ಏನಾರು ಹೇಳ್ಬೇಕಾ? ಯಾವತ್ತು ಅರೆಸ್ಟ್ ಆಗಿದ್ದು ನಿಮ್ಮವರು? ನೀವು ಹೇಳ್ಬೇಕು ಅಂತಾನೆ ನೆನ್ನೆ ಹೇಳ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ದು. ಎಸ್ ಮಿಸ್ಟರ್ ಪಾಸ್ ಓವರ್ ಮಾಡ್ತೀನಿ, ಕೇಳಿ ಹೇಳಿ. ಬಂದ್ರು ನೋಡಿ. ನಿಮ್ದೇನಾ? ನೆನ್ನೆದು ಮ್ಯಾಟ್ರು ನೀವು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿದಿರಿ. ಅದೇನೋ ಚಾರ್ಜ್ ಶೀಟ್ ಇಂದ ಆಗಿದೆ ಅಂತ ಆಗಿದೆ. ಅವ್ರ ಪ್ರಕಾರ ಸಿಂಪಲ್ ಇಂಜುರಿ ಅಂತಾರೆ, ನಿಮ್ ಪ್ರಕಾರ ಏನು ಬೇಕಾದ್ರೆ ಪಾಸ್ ಓವರ್ ಮಾಡಂದ್ರೆ ಮಾಡ್ತೀನಿ. ಅಷ್ಟೇ, ಅದೊಂದೇ ಬೇಕಾಗಿರೋದು. ಆಯ್ತು ಇವ್ರೆ, ನಾನು ಹೆಲ್ಮೆಟ್ ಇಂದ ಹೊಡೆದಿರೋದ ನಿಮ್ ಪ್ರಕಾರ ಏನ್ ಇಂಜುರಿ? ಅಷ್ಟೇ, ಮತ್ತೆ ಬಿಡಿ, ಅದಕ್ಕೋಸ್ಕರ ಕೇಳಿದ್ದಷ್ಟೇ. ವೈಶುಡ್ ಇದೆ. ಹಾರ್ಡ್ ಶ್ರೀ ಲತೀಫ್ ಬಿ ಅಂಡ್ ಲರ್ನಡ್ HGP ಅದು ತಗೊಳ್ಳಿದೆ, ಒಳಗೆ ಬಿತ್ತು, ಕಳಿಸ್ಬಿಡಿ ಅದನ್ನ. ಎಸ್, ವಿಲ್ ಕನ್ಸಿಡರ್ ಇಟ್. ಅಲ್ಲ ಆಯ್ತು, ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ, 307 ಆಗುವಂತದ್ದೇನಿರುತ್ತೆ? ನಾನು ಪದೇ ಪದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, 300 ಇಂಜುರಿ ಪ್ರೀವಿಯಸ್ ಇದ್ರೆ ದೇರ್ ಆರ್ ಅದರ್ ಸೆಕ್ಷನ್ಸ್ ಇನ್ ದಿ IPC. 326 ಇದೆ, ಅಲ್ಲೂ ಲೈಫ್ ಇಂಪ್ರಿಸನ್ಮೆಂಟ್ ಇದೆ. ಮೊಮೆಂಟ್ 307 ಅಂತಂದ್ರೆ ಒಂದು ಬಿಕಮ್ಸ್ ದಿ ಸೆಷನ್ಸ್ ಟ್ರಯಬಲ್. ಸೆಕೆಂಡ್ ಈಸ್ you will have to, the prosecution has to establish all ingredients that of a murder minus death. ಅದಕ್ಕೆ ಅದು ಹೈಯರ್ ಪೆಡೆಸ್ಟಲ್, ಗೊತ್ತಾಯ್ತಲ್ಲ? ಮೋಟಿವ್ ಇರಬೇಕು, ವಿತ್ ದಟ್ ಇಂಟೆನ್ಷನ್ ಅಸಾಲ್ಟ್ ಆಗಿರ್ಬೇಕು. ಅಸಾಲ್ಟ್ ಆಗುವಂತ ಸಂದರ್ಭದೊಳಗಡೆಗೆ ಆಪರ್ಚುನಿಟಿ ಇರುತ್ತೆ. ಆಪರ್ಚುನಿಟಿ ಇದ್ದಾಗ ಅವರು ಒಂದೇಟ್ ತಪ್ಪಿಸ್ಕೊಂಡ್ರೆ ಇನ್ನೊಂದೇಟ್ ಹೊಡಿದಲ್ನ ಯಾಕೆ ಬಿಡ್ತಾರೆ? ಕೊಲ್ಲೋ ಉದ್ದೇಶ ಇದ್ರೆ. ಆರ್ಡಿನರಿ ಸೊಳ್ಳೆ ಹೊಡಿವಾಗ ನೋಡ್ತೀರಿ, ಹಿಂಗಂತೀರಿ, ಸಿಕ್ಕಾಕೊಳ್ಳಲ್ಲ, ಇನ್ನೊಂದ್ಸತಿ ಟ್ರೈ ಮಾಡ್ತಿರೋ, ಇಲ್ಲ ಬಂದ್ ಕಚ್ಲಿ ಅಂತ ಬಿಡ್ತಿರೋ. ಅಂತದ್ರಲ್ಲಿ ಪ್ರಿಪೇರ್ ಆಗಿ ಹೋಗಿ ಮೋಟಿವ್ ಇಟ್ಕೊಂಡು ಇವತ್ತೊಂದು ಗತಿ ಕಾಣಿಸ್ಬೇಕು ಅಂತ ಹೇಳಿ ಮುಹೂರ್ತ ಫಿಕ್ಸ್ ಮಾಡಿ ಓದೋನು ಒಂದೇಟ್ ತಪ್ಪಿಸ್ಕೊಂಡ್ಬಿಟ್ಟ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಮಾತ್ರಕ್ಕೆ ಆಯ್ತು ಇವತ್ತು ಬಚಾವಾಗಿದ್ದೆ ಹೋಗು ಅಂದ್ಬಿಟ್ಟು ಬಂದ್ಬಿಡ್ತಾನ? ಮತ್ತೆ ಅದನ್ನೆಲ್ಲ ಹೇಳ್ಬೇಕು ನೀವು 307ಗೆ, ಗೊತ್ತಾಯ್ತಲ್ಲ? 307 ನಲ್ಲಿ ಅಟೆಂಪ್ಟ್ ಟು ಮರ್ಡರ್. ಸೊ ಮರ್ಡರ್ ಆಗಿದೆ, ಪರ್ ಚಾನ್ಸ್ ಅವ್ನು ಬಚಾಯಿಸ್ಕೊಂಡ್ಬಿಟ್ಟಿದ್ದಾನೆ. So the prosecution has to establish all these things. Otherwise 307 will go away. Correct ಅಪ್ಪ? ಹೊಡೆದಿದ್ದೀವಿ, ಹೆಡ್ ಹೊಡೆದಿದ್ದೀವಿ, ಹೆಲ್ಮೆಟ್ ತಗೊಂಡೇ ಹೊಡೆದಿದ್ದೀವಿ. ಆ ಘಟನೆಗೆ ಮೋಟಿವ್ ಏನು? With whether that incident has occurred at the spur of the moment or it was a premeditated. That is it. It is just ಗಲಾಟೆ ಬೇಕಲ್ಲ. ಓದಿ, ಅವಾಗ ನೀವು ಓದಿದ್ರೆ ಗೊತ್ತಾಗ್ಬಿಡುತ್ತೆ ನಿಮ್ ಪ್ಯಾರಾಗ್ರಾಫ್ ನ. ಎಸ್, ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ ಲತೀಫ್ ಅಂಡ್ ಲರ್ನಡ್ HGP, petition under section 439 CRPC with the following prayer. Next para. Brief facts of the case are as under. Shashikala R lodged a complaint with Kushal Nagar Town Police on 14th January 2023, which was registered in crime number 7/2023 for the offence punishable under section 498A, 307, 504, read section 30, 504 IPC. First, next para. List of the complaint governments reveal that the complainant is working as a head constable in Kushal Nagar Town Police Station and is residing in the police quarters. About 11 years earlier, she has married KG Nagendra and there are 2 children in the marriage, aged 9 years and 3 years respectively. First, it is her contention that her husband is a rate drunkard. ಹೌದಾ? ಡ್ರಂಕಾರ್ಡ್ ಇಂಪಾರ್ಟೆಂಟ್, ಟೀಚರ್ ಆದ್ರೆ ಅದು ಇಂಕ್ರಿಮಿನೇಟರಿ ಆಗಲ್ಲ. Great drunkard, and he had borrowed money from all possible sources and has become a defaulter. First, the loan of rupees 13 lakhs is made, a sum of rupees 13 lakhs is borrowed by her husband as loan from different people, and in that regard, there were serious differences between the complainant and the accused in their matrimonial relationship. First up. There was a annual sports meet between 14/11/2022 to 19/11/2022 at Madikeri, and complainant and her friends had participated in the annual sports meet, and they had commuted from Kushalnagar to Madikeri in the car of one of her colleagues by name Sandeep by sharing the petrol charges. First, in that regard, the accused petitioner has entertained doubt as to the fidelity of the complainant and picked up the quarrel. First, in the quarrel, the accused had assaulted the complainant with helmet on her head, resulting in injury. First, based on the complaint, police registered the case as aforesaid and filed the charge sheet against the and investigated the matter, and inter alia arrested the petitioner and took him to custody and then filed the charge sheet. First, Netpara. The charge sheet materials reveal that the complainant has sustained simple injury. First, Netpara. Whether at all the attempt made the attempt made by the petitioner to seek for grant of bail is seeking grant of bail is rejected by the learned district judge in CMIS number 53/2023 by order dated 23rd February 2023. Thereafter, petitioner is before this court. Next para. Sri Latif, learned counsel for the petitioner, vehemently contended that even assuming that the entire material on record is to be appreciated, is to be accepted as true for the purpose of argument, no ingredients whatsoever are made out to attract the offence punishable under section 307 IPC, and therefore sought for grant of bail. First, he also pointed out that since the charge sheet is filed and the petitioner is a teacher and is having permanent residence, continuation of the accused petitioner in judicial custody is no longer warranted and sought for a grant of bail. Per contra, next para. Per contra, learned HCGP opposes the bail grounds by reiterating the grounds in the objection statement. First, he also pointed out that petitioner had the habit of attacking the complainant for silly reasons, and the same was tolerated by the complainant all these years only with an intention to maintain the matrimonial relationship for the sake of the children. And when the petitioner has gone to the extent of assaulting the complainant on her head with helmet with an intention to take away her life, she could no longer tolerate the same and then approached the police, and therefore, petitioner is not entitled for grant of bail. First, next for in view of the rival contests of the parties, this court perused the material on record meticulously. Next para. On such perusal of the material on record, it is seen that the incident has occurred on an unfortunate day when the complainant had participated in the annual sports meet, and for that purpose, she had traveled in the car of a colleague of the complainant. First, the accused petitioner doubted her chastity and picked up the quarrel. In the spur of the moment, he has taken the helmet and assaulted the complainant on her head. First, whether at all the petitioner had the intention to kill the complainant or not, murder the complainant or not, cannot be decided by this court at this stage. First, it is for the learned trial judge to form an opinion as to the alleged guilt of the petitioner after the full-fledged trial based on the materials available on record. First, it is too premature, TOO, too premature for this court to assess the merits or demerits of the case at this stage by holding a mini trial, as the same may prejudice the case of the parties during the trial one way or the other. Next para. Suffice to say that since the charge sheet is filed, comma, and in the absence of any previous complaints, comma, this court is of the considered opinion, comma, considered opinion that the petitioner is entitled for grant of bail by resorting to the special powers vested in this court under section 439 CRPC. First, next para. The apprehensions expressed by the prosecution can be met with by imposing suitable and stringent conditions. First, ಈಗೇನು ಅವಳ ಜೊತೆ ಇರ್ತೀರೋ ನೀವು ಇರಲ್ವೋ ಹೆಂಗಿರ್ತೀರಿ ತಿರ್ಗಾ ಹೆಲ್ಮೆಟ್ ತಗೊಂಡು ನಾನು ಸಾಯಿಸ್ಬಿಟ್ರೆ ನೀವು ಬೇರೆ ರೆಸಿಡೆನ್ಸ್ ಮಾಡ್ಕೊಳ್ಳಿ. ಡೋಂಟ್ ಟ್ರೈ ಟು ಸ್ಟೇ ವಿತ್ ಹರ್. ಇದೆಲ್ಲ ಎಲ್ಲಿಗೆ ಬಂದು ಮುಟ್ಟುತ್ತೋ ಗೊತ್ತಿಲ್ಲ ಆಯ್ತಲ್ಲ, ಬಿಕಾಸ್ ದಿ ಅಪ್ರೆನ್ಷನ್ ಈಸ್ ಲೈಕ್ ದಟ್. ಟು ಸ್ಟೇ ಅವೇ. ಅಲ್ಟಿಮೇಟ್ಲಿ ಹೊಂದಾಣಿಕೆ ಆದ್ರೆ ಅಲ್ಲೆಲ್ಲ ಇದೆ ನೋಡ್ಕೊಳ್ಳಿ, ಏನಿದೆಯೋ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಜಡ್ಜ್ ಮುಂದೆ ಹೋಗಿ ಒಟ್ಟಿಗಿರ್ತೀವಿ ಅಂತ ಕೇಳ್ಕೊಂಡ್ರೆ ಉಂಟು. When you have filed a case and when you are facing a charge under section 307 IPC, allowing you to stay with the complainant in the same house may not be justified. So we'll impose that condition. Apprehension of the prosecution can be met with by imposing suitable and stringent conditions. Accordingly, following order. Section allowed. Petitioner is directed to be enlarged on bail by taking a bond in a sum of rupees 2 lakhs with 2 sureties for the like sum. First, petitioner shall make a separate residence till the conclusion of the trial. First, petitioner shall attend the court regularly. Petitioner shall not tamper the prosecution witnesses in any manner. Petitioner shall not leave the jurisdiction of Kodagu district without prior permission. Violation of any one of the conditions would entitle the prosecution to seek for cancellation of bail. ಬೇಕಾದ್ರೆ ಪ್ರೀತಿ ಉಕ್ಕಿ ಹರಿದ್ರೆ ಬಂದ್ ನಮ್ಮ ಹತ್ರನೇ ಕೇಳಿ, ಅವಾಗ ನಾನ್ ಬೇಕಾದ್ರೆ ಕಂಡೀಷನ್ ನ ಮಾಡಿಫೈ ಮಾಡ್ತೀನಿ. ಓ ನೋಡೋಣಪ್ಪ ಅವೆಲ್ಲ. ನಾನು 13 ಲಕ್ಷಕ್ಕೆ ಏನ್ ಮಾಡ್ತೀರಿ ಹೇಳಿ? ಅದಾಗೋ ತನಕ ಇದಾಗಲ್ವಲ್ಲ. ಹನುಮಾನ್ ಪಿಶಾಚಿ ಬಂದ್ಬಿಟ್ರೆ ಲತೀಫ್ ಅವ್ರೆ ಬಹಳ ಕಷ್ಟ. ತೆಲುಗಲ್ ಗಾದೆ ಇದೆ, ಅನುಮಾನಂ ಪೆದ್ದ ರೋಗಂ ಅಂತ. Once you start doubting your spouse, there cannot be any end for that. ಕನ್ನಡಿ ಹೊಡೆದೋದಂಗೆ, ಎಷ್ಟೇ ಚೆನ್ನಾಗಿ ನೀವು ಅರಾಲ್ ಡೇಟ್ ಹಚ್ಚಿದ್ರು ಫಿಕ್ಸ್ ಮಾಡಿದ್ರು ಆ ಗೀಟ್ ಕಾಣ್ತಾನೆ ಇರುತ್ತೆ. ಏನ್ ಮಾಡೋದು ನೋಡಿ, ಏನ್ ಮಾಡ್ತಿರೋ. ಈ ವಯಸ್ಸಿನಲ್ಲಿ ನಿಮ್ಗೆ 2ನೇ ಮದ್ವೆ ಆಗೋದ್ ಕಷ್ಟ. Yes, Nagaraj Hegde. Mr. Madhu CS. What is this matter, sir? Offense no. All right, you file objections. HGP 6 time ಅವ್ರು ಯಾರು ಅವರು? ತಾವ್ ಯಾರಮ್ಮ? ಈ ಕೇಸಿಗೆ ಸಂಬಂಧಪಟ್ಟವ್ರ? ತಮ್ಮ ಹೆಸರೇನಮ್ಮ? Mother of the deceased. Case called out. Shri Madhu, that counsel for the petitioner present. Mother of the deceased present. ರಾಮಲಕ್ಷ್ಮಮ್ಮನ ತಾವು ಲಾಯರ್ನ ಬೇರೆಯವ್ರನ್ನ ನೇಮಕ ಮಾಡ್ಕೊತೀರಾ? She submits that she also needs to be heard in the matter. HGP seeks time to file objections post after vacation. Right, HGP seeks time to file objections. Urgent. Patil Ray idera? Yes. Just idರಲ್ಲಿ bait money. All right. Wait money 50,000 ಅಂತ ಲಾಕ್ ಕಳಿಸ್ಕೊಟ್ಟು. ಎಲ್ಲ ಆಗಿದ್ದೆ ತಾನೆ, ಸಸ್ಪೆನ್ಷನ್ ಎಲ್ಲ ಆಗಿದೆಯಲ್ಲ. Would you like to file something? No. All right. Third, CH ಅಂತ ಸೇರಿಸ್ಬೇಕು. Learned senior counsel ಅಂದ್ರೆ ತಮ್ಮ ಹೆಸರು ಶ್ರೀ ಪ್ರಕಾಶ್ ಫಾರ್ BB ಪಾಟೀಲ್. ರಾಮಕೃಷ್ಣ ಪಾಟೀಲ್ ರೇ ಇನ್ನೂ ಒಂದಿರ್ಬೇಕು. ಇನ್ನೂ ಒಂದ್ ಯಾವ್ದೋ ಇದೆ ತಮ್ದು. ಎಸ್ ರಾಮಕೃಷ್ಣ ಯಾರದು? ಆ ಎಮ್ಮನೆ ಇರ್ಬೇಕು, ಈಗ ಹೋಗಿದ್ದವ್ರು ಹೊರಗಡೆ. ರಾಮಲಕ್ಷ್ಮಮ್ಮ ಅವ್ರಿಗೆ ಹೇಳಿ ಆ ಕಡೆ ಹೋಗಿ, ದೂರ ಹೋಗಿ ಅಂತೇಳಿ. ಅದೆಲ್ಲ ಗಲಾಟೆ ಮಾಡಬಾರ್ದಲ್ಲಿ. Yes, mister. No, what is, first tell me what is the offense? Our objections ಹಾಕ್ಲಿ. Objections ಹಾಕಿದ್ದಾರೆ. Yes. When were you arrested? 4:30. Who are you? ಸತ್ತಿದ್ಯಾರು? Read the complaint. All right. In ಸ್ವಲ್ಪ ದಿನ ಆಗ್ಲಿ ಬಿಡಿ. Again, you are the people who publicly made that to insulted her. I have seen it. If you want, I'll pass orders. ನಾವೆಲ್ಲ ಬಿಟ್ಬಿಡ್ಬೇಕು ಅಲ್ಲಿಗೆ. ನಾನು ನೋಡ್ಕೊಂಡಾದ್ಮೇಲೆ ಚೆಕ್ ಅಂತ ಅದಕ್ಕೇನೆ ಹೇಳಿದ್ದು. Yes, what is this matter? Who has filed objection? No, who has filed objection? 1 second. 1 second, sir. HGP has filed objections. What about you? ಏನು ಅವತ್ತು ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಕೊಡೆ ಕೇಳಿ ಅವ್ರಿಗೆ. All right. Yes, tell me, sir. What is the statement of that lady? What is the statement of that lady, sir?
Yes, father will always have complaint. There was a see, apparently. Father is complaint. That's about any act. Father is complaint, right? To complete.
Yes. Hmm. 1-6. Yes. Mr. For 2018 incident, why are you now lodging the complaint? All right. What should be done? No, what is the delay? How do you explain delay for 3 years, 4 years, 5 years? No, it's okay. Let him be there. No, that's okay. If it promise to marry is not an offense. Yes, what do you say, mister? What do you say? Correct, mister. What were you doing all these days? He was a major. ಅದೆಲ್ಲ ಆಯ್ತು ಅದೆಲ್ಲ ಹೋಗುವ ಜ್ಞಾನ ಇರ್ಲಿಲ್ವಾ? No, if you ask that in the emotional way, the court will also pounce upon you. What were you doing if you are there for last 4 years? You're a literate person, not an LTM. ಮಾಡಿಸ್ಕೋಬೇಕು ಅದ್ರ ಬಗ್ಗೆ ಗಲಾಟೆನೇ ಆಗಿರುತ್ತಾನೆ ಈಗ. ಆಯ್ತು ಈಗ ಅದನ್ನ ಮದುವೆ ಮಾಡ್ಕೋತಾರೆ, ನೀವು ಒಪ್ಕೋತೀರಾ? ರೇಪ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕ್ಬಿಟ್ಟು ಮದುವೆ ಮಾಡ್ಕೊ ಅಂದ್ರೆ ಎಲ್ಲ ಆಗುತ್ತೆ. ನೀವು ಕೇಸ್ ಹಾಕಿದ್ರೆ ಮದ್ವೆ ಹೆಂಗಾಗತ್ರಿ? ಆಯ್ತು ಇವ್ರೆ ಅದಕ್ಕೆ ಅವ್ರು ಕೊಟ್ಟಿದಾರಲ್ಲ, ಕೇಸ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅವ್ರದ್ದು ಕಂಪ್ಲೇಂಟ್ ಮೊದ್ಲಿದ್ಯಲ್ಲ, ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಮೊದ್ಲಿದ್ಯಲ್ಲ, ನೀವು ಅದ್ರಲ್ಲೋಗಿ ಬೇಲ್ ತಗೊಂಡ್ಮೇಲೆ ತಾನೇ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿದಿರಿ. ಬರ್ಕೊಳ್ಳಿ. ಹಾರ್ಡ್ ಶ್ರೀ ಟೋಮಿ ಸೊಬಾಸ್ಟಿಯನ್ ಅಂಡ್ ಲರ್ಡ್ HGP. ತಮ್ಮ ಹೆಸರೇನು? ಶ್ರೀ ಉಮೇಶ್ ಫಾರ್ ದಿ ಡಿಫೆಕ್ಟ್ ಆಫ್ ಕಂಪ್ಲೇಂಟ್. ಫಸ್ಟ್ ನೆಕ್ಸ್ಟ್ ಪರ. Brief facts of the case are as the petition under section. It's all right, we'll look into it, sir. We'll look into it. We'll look into it. Will you allow me to now dictate? Yes. Petition under section 439 CRPC, the following prayer. Brief facts of the case are as under. Victim lady lodged a complaint with the Kaglipura police station on 23rd of February 2023, which was registered in crime number 96/2023 for the following offences: pencil mark, annexure A, page number 11. Next para. Gist of the complaint governments reveal that the petitioner herein had a love affair with the victim lady, and initially the same was not accepted by the victim lady, and later on the relatives of the petitioner and friends persuaded her, and she had been to a resort in the year 1818, and then when she went there, there was nobody in the resort except the petitioner, and he forcibly had a sexual intercourse with the victim lady by tying her hands and legs and gagged her mouth. First. Thereafterwards, comma, he also made a he also told the victim lady that if she refuses to have the company with the petitioner, comma, video clip and the photos of compromising position would be published in the social media and putting such fear on the victim lady, comma, he went on having the physical relationship with the victim lady and failed to marry her and therefore sought for action. First, police, after registering the case, comma, are investigating the matter and arrested the petitioner. Inter alia arrested the petitioner on which date? February 2nd, 2023, and sent him to judicial custody. First, the attempt made by the petitioner to obtain an order of bail was turned down by the learned district judge by order dated 24th of March 2023 in Simis number 482 of 2023. Thereafter, petitioner is before this court. Next para. Sri Tommy Sebastian, learned senior counsel, vehemently contended that on the issue of marriage, comma, there was a scuffle and a case came to be registered by the very same police in crime number 94 bar 2023. 94 or what is 90? 94 of 2023. 94 of 2023. And the said complaint was lodged by the father of the petitioner, father of the victim, and in that regard, comma, the petitioner and other accused persons appeared before the court and they were enlarged on bail. First, on the very same day, comma, the victim lady has also lodged one more complaint, which is the present complaint, and the petitioner has been arrested in the said complaint. First, he contended that mere breach of promise to marry would not ipso facto result in an offense, and the physical relationship, if any, is consensual in nature, having regard to the fact that the victim lady is a major, and other aspects of the matter can be sorted out if there is a proper offer from the complainant and her relatives. First, ನಿಮ್ಮಲ್ಲಿ ಜಮಾತ್ ಹೋಗ್ಲಿಲ್ವಾ? ಏನ್ ಹೇಳಿದ್ರು ಅವರು? ಅಲ್ಲ, ಅವ್ರೇನ್ ಹೇಳಿದ್ರು? ಅದಲ್ಲಿ ಜಮಾತ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದು. ಸೆಟಲ್ಮೆಂಟ್ ಅಲ್ಲಮ್ಮ, ಅದೆಲ್ಲ ನೋಡಿ. Why don't you know, if ultimately if you had relationship, why don't you marry her? Full stop. Sri Tommy Sebastian also submits that if the matters are thrashed out in a cool and calm manner, comma, there would be every possibility of exploring the the petitioner would make every possible attempt to explore the marriage proposal and sought for grant of bail. Next para. Per contra, Sri Umesh, representing the de facto complainant, comma, contended that failure to marry has resulted in the scuffle, which resulted the father of the victim lady to lodge the complaint, and thereafter there was also a move for marriage proposal, and at that juncture, comma, the petitioner and their family members flatly refused to marry the victim lady, and therefore, comma, victim lady had to lodge the complaint for the offense of rape. And Therefore, comma, petitioner is not entitled for enlarging, not entitled for bail. Next para, learned HGP adopts the arguments of de facto complainant and submits that even though, comma, mere breach to marry a person would not ipso facto result in an offense, comma, fact of the physical relationship that the petitioner had with the complainant victim lady, complainant dash victim lady, cannot be lost sight of while entertaining the bail petition and sought for dismissal of the same. First, next para. ಇತ್ಕೊಳ್ಳಿ ಬಿಡ್ರಿ ಮೇಜರ್ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೊಂಡು ಏನ್ ಮಾಡೋಣ, ಪೆಟಿಷನ್ ಕ್ವಾಶ್ ಆಗ್ಬಿಡುತ್ತೆ ನಟರಾಜನ್ ಸಾಹೇಬ್ರ ಜಡ್ಜ್ಮೆಂಟ್ ಹಾಕೊಂಡ್ರೆ, ಕಂಪ್ಲೇಂಟೇ ಹೋಗ್ಬಿಡಲ್ವಾ? ಮತ್ತೆ ಯಾಕೆ ನಾವು ಎಲ್ಲ ಮಾತಾಡ್ಬೇಕು? ಲೆಟ್ ಅಸ್ ನಾಟ್ ವರಿ, ಲೆಟ್ ಅಸ್ ಓನ್ಲಿ ಕೀಪ್ ಆಸ್ ಇಟ್ ಇಸ್. ಅವ್ರು ಇವಾಗ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ಸೀನಿಯರ್ ಹೇಳ್ತಾ ಇದ್ದಾರೆ, ತಾವು ಇದನ್ನೆಲ್ಲ ಬಿಟ್ಬಿಟ್ಟು ಕೂಲ್ ಅಂಡ್ ಕಾಮ್ ಆಗಿ ಕೂತ್ಕೊಂಡು ಏನಾದ್ರು ಮಾತಾಡಿದ್ರೆ ತೀರ್ಮಾನ ಆಗತ್ತೆ. ಅದನ್ನೇ ನಾನು ಹೇಳಿದ್ದೀನಿ. ನೆಕ್ಸ್ಟ್ ಪರ, ಇನ್ನು ದಿ ರೈವಲ್ contentions of the parties, comma, this court perused the matter on record meticulously. Next para. Admittedly, comma, there was a love affair between the petitioner and the victim lady. First, what made the petitioner and victim lady to fall apart is not forthcoming on record. Petitioner and the victim lady belong to the Muslim community and they had also gone to the Jamaat for redressal of the differences. First, for sorting out their differences. First, next para. However, since nothing fruitful has resulted, comma, the father of the victim lady lodged the complaint with the police, which was registered in crime number 94 of 2023. First, in that matter, comma, petitioner and others appeared before the court and they were enlarged on the bail. First, maybe with an intention to see that the marriage proposal is accepted by the petitioner and their family members, comma, the second complaint came to be lodged by the victim lady, alleging about the incident that occurred in the year 2018 and 19. First, the long silence is a relevant factor while considering the bail request. First, long silence in not complaining about the first. Since the victim lady is a major and the incident is not reported, prima facie it appears that the alleged act is a consensual act. Wherefore, first, wherefore, comma, prima facie there are materials on record that the complaint is filed on account of the refusal to marry the victim lady by the petitioner. First, Sri Tommy Sebastian, learned senior counsel, while addressing the arguments, comma, made a submission that the matter can be thrashed out in a cool and calm atmosphere, and if there is a proper approach by the victim lady and her family members, comma, the petitioner would still explore the possibility of marrying the victim lady. First, the statement made by the senior counsel is a responsible statement which would inspire the confidence of this court. First, placing such submission on record, comma, continuing the accused in judicial custody would only act as an obstacle for the said proposal. First, the apprehension of the prosecution that the petitioner may trouble the victim lady with the alleged photographs and videographs can also be met with by imposing suitable and stringent conditions. First, since the matter is in view of the above factual aspects of the matter, comma, above peculiar facts and circumstances of the case, comma, this court is of the considered opinion that the continuation of the petitioner in judicial custody is no longer warranted. The investigation would have also progressed to the sufficient extent, taking note of the fact that the accused is in custody on and from 2nd February 2023. First, allowing the petitioner to be on bail and creating an atmosphere for the amicable settlement would meet the ends of justice. First, accordingly, following order, bail petition allowed, petitioner be enlarged on bail on taking a bond in a sum of rupees 2 lakhs with 2 sureties for the like sum. First, petitioner shall not hamper the prosecution witnesses in any manner. Tamper madi. Petitioner shall not threaten the victim lady, stroke complainant, or her family members in any manner, including the blackmailing of the alleged photograph and videographs, blackmailing the victim lady by publishing the alleged photographs or videographs. First, ಏನಾದ್ರು ಸಿಕ್ಕಿದ್ಯಾ ಆ ತರದ್ದು ಮೊಬೈಲ್ ನಲ್ಲಿ ನೀವು ತನಿಖೆನಲ್ಲಿ ಮತ್ತೆ ನೋಡ್ಬೇಕಲ್ಲ, ಇಷ್ಟಂಕ ಇದಾರಲ್ಲ ಅವರು. ನೆಕ್ಸ್ಟ್ ಪರ, petitioner shall not, petitioner ಇರ್ಲಿ ನೋಡಿದ್ರೆ ಮುಗ್ದೋಗಿರುತ್ತಲ್ಲ ಅದು, ಅದೆಲ್ಲ ಅವ್ರು ಬಂದ್ ಮಾಡಿರ್ತಾರಲ್ಲ ಪೊಲೀಸ್ನವ್ರು. petitioner shall attend the court regularly. Petitioner shall mark his attendance before the investigation officer every third Sunday between 10 a.m. to 2 p.m. till the final report is filed. Petitioner shall not leave the jurisdiction of Ramnagara district without prior permission. Violation of any one of the conditions would entitle the prosecutor to seek for cancellation of bail. 2-3 ಮಾಡಿ. Bangalore rural district. 2-2 ಬೇಡ, 2-3 ಮಾಡಿ. Yes. ಬಸವಣ್ಣ, ಏನಿದು? ವಾಟ್ ಈಸ್ ದಿಸ್ ಸಬ್ಮಿಷನ್? ಅಲ್ಲ, ವಾಟ್ ಈಸ್ ದಿಸ್ ಸಬ್ಮಿಷನ್? ಅದೇ ಪೇಜ್ ನಂಬರ್ 10 and 28. All right, office objections overruled. Let HGP to take notice. Let HGP seeks time to file objections. What happened to second accused? ಆಯ್ತು. ಯಾವತ್ತಾಯ್ತು ಅದು ಸರ್ವಿಸು? ಯಾವತ್ತಾಯ್ತು? In order to facilitate the second respondent to engage a counsel, release this matter after vacation. 4:38 sir. ನಾನು ಇದ್ದಿದ್ರೆ ನೋಡ್ತಾ ಇದ್ದೆ. No, nothing. All right. In order to facilitate the second respondent, matter stands urgent. ನೀವು ಬೇಕಾದ್ರೆ ಮೂವ್ ಮಾಡಿ. No. ಅವೆಲ್ಲ ಬೇಡ. ಅವ್ರನ್ನ ಕೇಳೋ ತನಕ ನಾವೇನು ಮಾಡಕ್ಕಾಗಲ್ಲ. ಅವರು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕು, ಕೇಳ್ಬೇಕು. ಪೋಕ್ಸೋ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಸುಲಭ ಮಾಡ್ಕೊಳಕ್ ಹೋಗ್ಬೇಡಿ. ಬಸವಣ್ಣ ಅವರೇ, 302 ಮ್ಯಾಟರ್ ನಲ್ಲೇ ನಿಮ್ದೆಲ್ಲ ಮಾಡ್ಕೊಟ್ಟಿದ್ದೀನಿ. ಇಂಥದ್ರಲ್ಲೆಲ್ಲ ಯಾಕೆ ಆಗ್ಬಾರ್ದು? ನಾನೇನು ಹೇಳಲ್ಲ, ಅದ್ ನೀವು ಅಲ್ಲಿ ನೋಡ್ಕೊಳ್ಳಿ, ಅಲ್ಲಿ ನೋಡಿ ಎಲ್ಲ ನೋಟಿಫಿಕೇಶನ್ ಬಂದಿದೆ. No, we cannot direct. You should move the vacation court. Vacation court should find urgency and then take it. ನಾನೆಲ್ಲ ಬಂದಿದೆ, ನೋಡಿದ್ದೀನಿ. Yes. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೇಕಲ್ಲ ಅವ್ರು. ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ, ಹಾಕ್ಲಿ. Objections, HGP seeks time. Urgent. Yes. Hiremat.
My lords, appear for petition in this matter, my lords.
Yes.
354D, my lords. And 324, my lords, and 12 of my lords.
ಬಂದರೆ they want to engage a counsel. Let us see. ಏನ್ ಮಾಡ್ತಾರೆ ನೋಡಿ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಎಂಗೇಜ್ ಮಾಡಲಿಲ್ಲ ಸ್ವಾಮಿ, ಬರ್ಲೇ ಇಲ್ಲ ಅವರು.
ಬಂದಿದ್ದಾರೆ ರೀ, ಸ್ವಲ್ಪ ನೋಡೋಣ, ತಡೀರಿ. ಯಾಕೆ?
ಪ್ಲೀಸ್.
Why unnecessary haste?
ಪ್ಲೀಸ್.
ಏನಂತಪ್ಪ ಅವರು? ಏನಾರು ಒಂದು ಹೇಳಿ ಬೇಗ. All right. Second respondent present before the court submits that the learned HGP would protect the interest of the second respondent as well. Learned HGP seeks time to file objections urgent.
Problem.
Yes, please. ನೀವು ಯಾರು? ಆಯ್ತು ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕ್ಲಿ ಬಿಡಿ. HGP seeks time to file objections again. Yes. Mr. Patil, what is the amount involved in this? ಓಹೋ ಆಯ್ತು ಇವ್ರೆ, ಎಲ್ಲ ಆಗಿದೆ ತಾನೆ ಸಸ್ಪೆನ್ಷನ್ ಎಲ್ಲಾನು. ಇದರಲ್ಲಿ ಬೈಟ್ ಮನಿ 9,000 ಅಂತ ಹಾಕಿ ಕಳಿಸಿ. ರಾಜು ಏನು ನಾನ್ ಅವೆಲ್ಲ ಏನ್ ಮಾಡಲ್ಲ, ಸೋಮವಾರ ತಗೊಳ್ಳಿ ನೀವು. ಒಳ್ಳೆ ಚೆನ್ನಾಗಾಯ್ತಲ್ಲ, ಚೆನ್ನಾಗಾಯ್ತು ಇದಲ್ಲೇ. ಅದ್ಯಾವ್ದಲ್ಲ ಏನು ಬೇಡ, ಒಳಗಡೆ ಇದ್ದಾನೆ ಇರ್ಲಿ ಇನ್ನೊಂದ್ 2 ದಿವಸ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಸ್ಟೂಡೆಂಟು ಇವ್ರೆ, ಸ್ಟೂಡೆಂಟ್ HGP ಸ್ಟೂಡೆಂಟ್ ಹಾಸ್ಟ್ಲು 395. Objections filed, heard. Raju CN and Srinivasa KV and objections filed taken on record. Adrolna adna ಬರೆದ್ಬಿಡಿ ಆರ್ಡ್ ಶೀಟ್ ಅಲ್ಲಿ. ಇದರಲ್ಲಿ heard ಶ್ರೀ ರಾಜು CN ಶ್ರೀನಿವಾಸ ಜೊತೆ ಜಾಯಿಂಟ್ ಪೆಟಿಷನ್ ಹೇಳ್ಬಿಡಿ ಆಯ್ತಾ. And HGP petitions under section 439 CRPC with the following prayers. ಎರಡರದನ್ನ ಹಾಕ್ಬಿಡಿ. Next para brief facts of the case are as under. Next para a complaint came to be lodged by Ratneshwar, son of Ratan Kumar, with Yelahanka police on 22/3/2023. It was registered in crime number 115/2023 for the offence principle under section 397 IPC. List of the complaint governments revealed that on 20th March 2023 at about 5:30 p.m, when complainant along with his friends were in the room chit-chatting each other, 5 unknown persons barged into room and put the petitioner, complainant and others in fear by showing the cricket bat and hockey sticks and snatched away somehow rupees 22,514 by getting it an online transfer. First, based on the complaint, police registered the case against the unknown persons at the first instance, and during the course of investigation apprehended the present petitioners and they were sent to judicial custody. Attempt made by them to obtain an order of bail was turned down by the learned district judge. Thereafter petitioners are before this court. Next para reiterating the grounds set in the petition, Sri Raju CN and Srinivasa KV vehemently contended that the petitioners are students and they are no way connected with the incident, and they have been partially implicated in the case and sought for grant of bail. Per control and HGP reiterating the grounds set in the objection statement opposite the bail grounds. First, next para perused the matter on record meticulously in of the rival contents of the parties. First, next para admittedly, the incident has occurred in the room of the hostel where the complainant and his friends were there. There was a fear that was put to them with by showing the cricket bat and hockey stick, and there was an online transfer of rupees 22,514. First, whether at all the said money has come to the account of the petitioners or not, and whether the same was under the fear and which would amount to an offence under section 392 IPC, and whether 397 of the IPC gets attracted or not cannot be decided by this court at this stage by holding the mini trial. First, it is for the investigation agency to file appropriate report after thorough investigation, and for the learned trial judge to form an opinion about the guilt of the petitioner after the full-fledged trial. Next para, taking note of the fact that the petitioners are students and there is no criminal antecedents in respect of the petitioners, this court is of the considered opinion that continuation of the present petitioners in judicial custody is no longer warranted. First, the apprehensions of the prosecution can be met with by imposing suitable and stringent conditions. Accordingly, following order, petition allowed. Petitioners are directed to be enlarged on bail by taking a bond in a sum of rupees 1 lakh with 2 sureties for the like sum. Petitioners shall not indulge in similar offences. Petitioners shall not tamper the prosecution witnesses. Petitioners shall attend the court regularly. Petitioners shall mark their attendance before the investigation officer every third Sunday between 10 a.m. to 2 p.m. till the final report is filed. petitioner shall not leave the jurisdiction of Bangalore district without prior permission. A violation of any one of the conditions would entitle the prosecution to sue for cancellation of bail. Yes, passed over matter. ಬರ್ತಾರೆ ಅವ್ರು ಇದ್ದಾರೆ ಹೊರಗಡೆ ಇದ್ದಾರೆ. Case called twice, none present. Objections filed. HCGP seeks time to file objections urgent. ಯಾರದು ಯೋಗೇಶ್ ಅಂದ್ರೆ ಏನ್ ಮಾತಾಡೋದು ಎಲ್ಲ ಪಕ್ಕದ ಕೋರ್ಟಲ್ಲಿ ಇದ್ದಾರೆ ಅನ್ನಲ್ಲ ಮತ್ತೆ ಹೋಗ್ಬಿಟ್ಟು ಎಸ್ ಈ ಮೂರು ಟಿಪಿ ಅವರೇ ನಿಮ್ದು 8, 10, 12. Objections filed taken on record. Heard Sri Hasmat Pasha, learned senior counsel and learned HCGP. First, next. These three petitions are filed under section 439 CRPC with the following prayer by accused number 8, 10 and 12 in crime number 73 of 2022 of Tiptur Rural Police. First, brief facts of the case are as under. Next para. Basuraju HV, son of late Virupakshappa, lodged a complaint with Tiptur Rural PS on 25/10/2022, which was registered in crime number 73 of 2022 for the offence principal under section 302, 307, 324, 447, 448, 143, 147, 148 and 149 IPC. Next, the register of the complaint government revealed that on 25/10/2022, on ಹೆಸರಿನ ಸತ್ತೋದನ ಹೆಸರು Sri Divakar had arranged a birthday party in a coconut garden, in a shed in a garden land, in a shed in garden land. Yavattu on 24/10/2022 at about 4 PM. First, the arrangements for the birthday party were made, and the Sri Divakar and his friends proceeded to the set spot. First, he had invited limited number of his friends. First, he was fearing about his life as well, and therefore he had kept these petitioners for watch, expecting some untoward incident, preventing an untoward incident. Divakarge all right, okay. Divakar had invited limited number of friends, and they were in the amidst of party, accused number 1 gained entry inside the party area and picked up the quarrel with Divakar and assaulted him. First, two accused number 1 and 2. First, CW3 saw the incident and wanted to report the same to the friends and public, rushed out of the party area, and at that juncture, accused number 6 assaulted CW3. ಹೆಸರೇನು ಅವ್ರದ್ದು ರವೀಶ್ ಬ್ರಾಕೆಟಲ್ CW3 ಅಂತ ರವೀಶ್ ಅಂತ ಹಾಕ್ಬಿಟ್ಟು one Ravish saw the incident, ಬ್ರಾಕೆಟಲ್ CW3 ಅಂತ. Next para. The present petitioners were kept as a watch to prevent the untoward incident in accomplishing the act by accused number 1, 2 and others. 1, 2 and others, and these petitioners were keeping a watch outside the party area. First, as soon as Ravish came out, these petitioners thought that some untoward incident has occurred inside and they were rushing towards the party area. Full stop. At that juncture, accused number 6 assaulted Ravish. Full stop. ಹೊರಗಡೆ ಬರುವಾಗ ಅಂತ. Next para. Even according after first stop. They went inside and saw that Divakar was no more. ಹೋಗಿದಾರಲ್ಲ ಹೇಳಿದ್ದಾರೆ ಅವರು ಎಲ್ಲ ಇದ್ರು ಅಂತ. And they ran away from the spot. After seeing the incident, they ran away. The present petitioner ran away from the spot. Full stop. The incident was reported to the police by Basuraju, and police registered the case and investigated the matter. Inter alia arrested these petitioners. Full stop. After thorough investigation, charge sheet came to be filed. Even according to the police, the role assigned to the present, even according to the charge sheet materials, the role assigned to the present petitioners is that they were keeping a watch outside in order to prevent somebody else obstructing the accomplishment of the murder of Divakara by accused number 1 and 2. Full stop. Next para. The attempt made by the petitioners to obtain an order of grant of bail is turned down by the learned district judge. And learned district judge Tumkur sitting at Tiptur. First, thereafter petitioners are before this court. Next para. Shri Hasmat Pasha, learned senior counsel, vehemently contended that the material on record, if accepted, the charge sheet materials, even if it is accepted as true for the sake of argument, the role that is assigned to the present petitioners is only to the extent of keeping a watch. First, no witnesses have stated that these petitioners also shared the common object of taking away the life of Divakar, and therefore, continuation of the present petitioners in judicial custody is no longer warranted. First, he also contended that the material evidence on record would only go to show that after the incident, these petitioners ran away from the spot, and therefore, no, in the absence of any active participation of these petitioners, no vote act could be attributed to the present petitioners by resorting to the provision under section 149 of the IPC and sought for grant of bail. At the most, the material on record would only establish the presence of the petitioner at the spot at the relevant time of incident, which would not disentitle the present petitioners to obtain an order of grant of bail by resorting to the special powers vested in this court under section 439 CRPC and sought for allowing the petitions. Next para. Per contra, learned HCGP opposes the bail grounds by reiterating the grounds set in the objection statement. Next para. In of the rival contents of the parties, this court, next para, he also contended that when the prosecution has invoked section 149 IPC, individual overtax would lose its significance, and therefore, an act of one accused would be shared by the would be held liable. Act of one person would also bind the other accused, and therefore sought for rejection of the bail petition. ಇದ್ದು ಅನ್ನೋದಕ್ಕೆ ಏನು ತಕರಾರಿಲ್ಲ. ನಿಮಗೆ ನಾನು ಈಗಲೇ ಹೇಳಲ್ಲ, ಗೊತ್ತಿರುತ್ತೆ, ನಾನೇನು ಹೇಳಬೇಕಾಗಿಲ್ಲ. ಜಸ್ಟಿಸ್ ಅರಿಜಿತ್ ಪಸಾಯತ್ ಅವ್ರದ್ದು ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. ದಟ್ ಇಸ್ ದಿ ಜಜ್ಮೆಂಟ್ ಆನ್ ದಿ ಕಾಮನ್ ಆಬ್ಜೆಕ್ಟ್. ಆಯ್ತಾ? ದೇರ್ ಲಾರ್ಡ್ಶಿಪ್ಸ್, ಆಫ್ಟರ್ ಸರ್ವೇಯಿಂಗ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್, ದಿ ರೆಲೆವೆಂಟ್ ಏರಿಯಾಸ್, relevant decisions, how a 149 to be applied in a given case anta heltare. Two important facts to be remembered there. One is presence, the second is participation. Now there are two way of participation. One is active participation. ಅವನು ಹೊಡಿತಿರ್ತಾನೆ, ನನ್ ಕಂಡ್ರೆ ಆಗೋದಿಲ್ಲ, ನೀವು ಶಕ್ತಿವಂತರು, ನೀವು ನನ್ಗೆ ಹೊಡಿತಿರ್ತೀರಿ, ಅವನಿದ್ದಾನೆ, ಅವನ್ ಶಕ್ತಿವಂತ ಅಲ್ಲ, ಆದ್ರೆ ಅವನಿಗೂ ಇದೆ ನನ್ನ ಮೇಲೆ ಸೇಡ್ ತೀರ್ಸ್ಕೋಬೇಕು ಅಂತ, ಒಳ್ಳೆ ಚಾನ್ಸ್, ಬಿಡಬೇಡ ಮಗ್ಸೋ ಅವನ್ನ. ಇದು ಆಕ್ಟಿವ್ ಪಾರ್ಟಿಸಿಪೇಷನ್. ತಾಕತ್ತಿತ್ತು ಅಂತಂದ್ರೆ ಅವ್ನು ಹೊಡಿತಿರ್ತಾನೆ, ಇವನು ಒಂದೇಟ್ ಕಲ್ ತಗೊಂಡು ರಪಾರ್ ಅಂತ ಎಸಿತಾನೆ, ತೋಳ ಹಳ್ಳಕ್ ಬಿದ್ರೆ ಆಳ್ಗೊಂದ್ ಕಲ್ಲು ಅಂತ. ಆಯ್ತಾ? ತೋಳ ಹೊರಗಡೆ ಇದ್ದಾಗ ಯಾರು ತಕರಾರಿಲ್ಲ, ಯಾಕಂದ್ರೆ ಅದೇನ್ ಮಾಡುತ್ತೋ ಅಂತ ಭಯ. ತೋಳ ಹಳ್ಳಕ್ ಬಿದ್ದಾಗ ಎಲ್ಲ ಪೌರುಷ ತೋರಿಸೋದು, ಇದಕ್ಕೆ ಆಕ್ಟಿವ್ ಪಾರ್ಟಿಸಿಪೇಷನ್ ಅಂತ. ಪ್ಯಾಸಿವ್ ಪಾರ್ಟಿಸಿಪೇಷನ್ ಅಂದೇನಂತಂದ್ರೆ ನಾನಂತೂ ಹೊಡಿಯಕ್ಕಾಗ್ಲಿಲ್ಲ, ಮಕ್ಕಳು ಹೊಡಿತಿದ್ದಾರೆ, ನನ್ನಷ್ಟಕ್ಕೆ ನಾನು ಇರೋಣ, ಖುಷಿ ತಗೊಳ್ಳೋಣ, ಮಜಾ ತಗೊಳ್ಳೋಣ. ಇದು ಪ್ಯಾಸಿವ್ ಪಾರ್ಟಿಸಿಪೇಷನ್. ನಾಟ್ ಇಂಟರ್ಫಿಯರಿಂಗ್, ನಾಟ್ ಪ್ರಿವೆಂಟಿಂಗ್ ದಿ ಆಕ್ಟ್ ವುಡ್ ಅಮೌಂಟ್ ಟು ಪ್ಯಾಸಿವ್ ಪಾರ್ಟಿಸಿಪೇಷನ್ ಅಂತ. ಗೊತ್ತಾಯ್ತಲ್ಲ? ಅದು ಯಾಕೆ ಅಂತಂದ್ರೆ ಯು ಆಲ್ಸೋ ಶೇರ್ ದಿ ಆಬ್ಜೆಕ್ಟ್ ದಟ್ ಕೀಟ ಹೆಂಗೋ ಸತ್ತೋಗ್ತಾ ಇದೆ, ಕ್ರಿಮಿ ಸಾಯ್ಲಿ, ಹೊಸಕ್ ಬಿಡ್ಲಿ ಅವರು, ನಾನು ಖುಷಿ ಪಡೋಣ. ಸೊ ಇದು ಪ್ಯಾಸಿವ್ ಪಾರ್ಟಿಸಿಪೇಷನ್. ಹಿಂಗಿರುವಾಗ ಈ ಎರಡು ಫ್ಯಾಕ್ಟರ್ಸ್ ಪ್ರೂವ್ ಆಗದೆ ಇದ್ರೆ ಬರೇ ಪ್ರೆಸೆನ್ಸ್ ಇದ್ರೆ ಅಕ್ವಿಟಲ್. ಪಾರ್ಟಿಸಿಪೇಷನ್ ಮೀನ್ಸ್ ದೇರ್ ಮಸ್ಟ್ ಬಿ ಪ್ರಿಸಪೋಸಸ್ ದಿ ಪ್ರೆಸೆನ್ಸ್. ಸೊ ಅಷ್ಟಕ್ಕೆ ಹೋಗ್ಬಿಡುತ್ತೆ. ಯಾಕೆ ಅಂದ್ರೆ ಹೇಳ್ತಾರೆ ದೇರ್ ಮೇ ಬಿ ಎ ಪರ್ಸನ್ ಹೂ ಇಸ್ ಅನ್ ಆನ್ ಲುಕರ್, ಕ್ಯೂರಿಯಾಸಿಟಿ, ಎಲ್ಲೋ ಏನೋ ಆಗ್ತಿರುತ್ತೆ, ಗಲಾಟೆ ಎಲ್ಲ, ನಾವು ಹೋಗಿ ನೋಡ್ತಾ ನಿಂತಿರ್ತೀವಿ, ಹೊಡಿತಿರ್ತಾರೆ, ಅಯ್ಯೋ ಅಯ್ಯೋ ಅಂತಿರ್ತೀವಿ ನಾವು. ಹಿಂಗೆ CCTV ತೆಗಿದ್ರೆ ನಾನು ಸಿಕ್ಕಾಕೊಂಡ್ಬಿಡ್ತೀನಿ. ನಾನು ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ನಾ? ನಿಮ್ಮ ಸಿಟಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಇನ್ಸಿಡೆಂಟ್ ನೋಡಿ, 8 ಜನ ಲಾಯರ್ ನೋಡ್ತಾ ನಿಂತಿದ್ರು, ಅವರೆಲ್ಲ ಅಕ್ಯೂಸ್ಡ್ ಪೊಲೀಸ್ ಹೊಡೆದಾಗ, ಮೀಡಿಯಾದವ್ರು ಹೊಡೆದಾಗ, ಮೆನಿ ಆಫ್ ದೆಮ್ ವರ್ ಸೀಯಿಂಗ್ ಫ್ರಮ್ ಆಲ್ ದಿ ಫ್ಲೋರ್ಸ್. ಯು ಸಿ, ವಿಡಿಯೋ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದಾನಲ್ಲ ಪಬ್ಲಿಕ್ ಟಿವಿನವನು. ಆಲ್ ಆಫ್ ಯು ಆರ್ ಅಕ್ಯೂಸ್ಡ್. ದೇರ್ ಮೇ ಬಿ an onlooker. You were present. Did you participate is the issue. ಯಾರೋ ಇಟ್ಗೆ ತಗೊಂಬಂದು ಹೊಡಿತಿರೋದು ಮಾತ್ರ ಪಾರ್ಟಿಸಿಪೇಷನ್. ಅವನ್ ಲಾಯರೇ ಅಲ್ಲ. See, beautifully you must see that judgment. ತುಂಬಾ ಚೆನ್ನಾಗಿರುತ್ತೆ, ಎಂಜಾಯ್ ಮಾಡೋದಕ್ಕೆ. I have referred in many cases. You can go through that. Presence and participation. Participation has got two wings, active and passive. ಇದು ಟ್ರಯಲ್ ನಲ್ಲಿ ತೀರ್ಮಾನ ಮಾಡಿ. ಇವ್ರು 3 ಜನ ಹೊರಗಡೆ ಇದ್ರು, ನಾವ್ ಒಳಗಡೆ ಹೋಗ್ತೀವಿ, ಮುಗಿಸ್ ಬರ್ತೀವಿ, ಅವ್ರ ಕಡೆಯವ್ರು ಯಾರು ರೌಡಿ ಗಿಡಿ ಬಂದ್ಬಿಟ್ಟಾರು, ನೋಡ್ಕೊತಾ ಇರಿ, ಬಿದ್ರೆ ನಮಗೆ ಇದಾಕಿ ಸಿಗ್ನಲ್ ಕೊಡಿ, ನಾವೊಂದು ಎಸ್ಕೇಪ್ ಆಗ್ಬಿಡ್ತೀವಿ, ಇಲ್ದರೆ ಮುಗಿಸ್ಬಿಟ್ಟು ಬಂದ್ಬಿಡ್ತೀವಿ, ನೀವು ನಮ್ ಹೊರಗಡೆ ಇದ್ದು ವಾಚ್ ಮಾಡಿ ಅಂತ ಹೇಳಿರು ಅಂತದ್ದು ಅಂತ ನಿಮ್ ಪ್ರಕಾರ ಯಾರೋ ಸ್ಟೇಟ್ಮೆಂಟ್ ಹೇಳ್ಬೇಕು. ನಾಳೆ ಯಾರು ಹೇಳ್ತಾರೆ ಇದನ್ನ? ಇದು ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ದೋಸ್ತರಿ. ಅದ್ ಬಿಟ್ರೆ ಹೇಳೋರು ಯಾರು? ಈಗ ಯಾವ್ದೋ ಘಟನೆ ನಡೆಯೋ ಮುಂದೆ 3 ಜನ ನಿಂತಿರ್ತಾರೆ, ಏನ್ ನೀವೇನು ಇದಿಟ್ಕೊಂಡಿದ್ದೀರಾ ಮಿಷಿನ್, ಓ ಏನಕ್ಕೆ ನಿಂತಿದ್ದಾರೆ ಅಂತ ಹಿಂಗಂದ್ರೆ ಇವ್ರು ವಾಚ್ಗೆ ಇಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಬೇಸ್ಡ್ ಆನ್ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಯುವರ್ ಸೆಲ್ಫ್. ವೈ ವರ್ ಯು ದೇರ್ ಅಂದ್ರೆ ಇಟ್ಸ್ ಎ ಪಬ್ಲಿಕ್ ರೋಡ್, ಐ ಆಮ್ ದೇರ್, ವಾಟ್ ಕ್ಯಾನ್ ಬಿ ಡನ್? ಎಸ್, so and so was known to me, I am also there. ಅಷ್ಟ ಇದೆ ಅಲ್ಲ. ಅದೇ ಈಗೆಲ್ಲ ಹೇಳ್ಬಾರ್ದು, ಹೇಳಿದ್ರೆ ಏನಾಗುತ್ತೆ, ಟ್ರಯಲ್ ಎಲ್ಲ ಕೋರ್ಸ್ ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ, ಅವ್ರು ಮಾಡ್ತಿರೋದು ಬೇರೆ ಪ್ರಶ್ನೆ. ಈಗ ಹೇಳ್ಬಿಟ್ರೆ ಅದು ಟ್ರಯಲ್ ನಲ್ಲಿ ಹೆಚ್ಚು ಕಮ್ಮಿ ಆಗ್ಬಿಡುತ್ತೆ. ಅದಕ್ಕೆ ಮಿನಿ ಟ್ರಯಲ್ ಬೇಡ ಅಂತ ಹೇಳಿ. ಎನಿವೇ, ದಿಸ್ ಇಸ್ ಮೈ ಲಾಸ್ಟ್ ಡೇ ಇನ್ ದಿ ರೋಸ್ಟರ್, ದೇರ್ ಫಾರ್ ಐ ಆಮ್ ಗಿವಿಂಗ್ ಬಿಟ್ ಆಫ್ ಮೈ ಮೈಂಡ್. ಎಸ್ ಮಾ, ಎಲ್ಲಿಗೆ ಬಂತಮ್ಮ? Yes, next para. In view of the rival contentions of the parties, this court perused the matter on record meticulously. On such perusal of the matter on record, it is seen that the present petitioners were roped in the incident, and the role assigned to the present petitioners is that they had kept a watch to prevent the possible obstruction in accomplishment of the act committed by accused number 1 and 2. Full stop. Whether at all these petitioners 1 to 3, whether at all these petitioners shared the common object of murdering the Divakar and also assaulting Ravish, capital CW3 or not, cannot be decided by this court at this stage by holding a mini trial. Full stop. Suffice to say that the accused petitioners are in custody and the charge sheet is filed, taking note of the role assigned to the present petitioners, this court is of the considered opinion that the continuation of the accused petitioners in judicial custody is no longer warranted. First up, the apprehensions of the prosecution can be, including the ground of parity, can be met with by imposing suitable and stringent conditions. Accordingly, following order, petition allowed. Petitioners are directed to be enlarged on bail by taking a bond in a sum of ₹2 lakhs with 2 sureties for the like sum. First, petitioner shall not tamper the prosecution witnesses in any manner. Petitioner shall attend the court regularly. Petitioner shall not leave the jurisdiction of Tumkur district without prior permission. First, grant of bail to the present petitioners would not ipso facto act as a parity insofar as the other accused persons. Violation of any one of the conditions would entitle the prosecution to seek for cancellation of bail. ಮುಗಿತಮ್ಮ? ಸೋಮವಾರ ಕೊಡ್ತಾರೆ ಬಿಡಿ, ನೀವು ಒಳ್ಳೆ ಚೆನ್ನಾಗಿರ್ತೀರಿ. ನಾನೇ ಇಲ್ಲ, ನಾಳೆ ಆದ್ಮೇಲೆ ನಾನೆಲ್ಲ ಸೈನ್ ಮಾಡ್ತೀನಿ. ಇವರೆಲ್ಲ ಇರ್ತಾರೆ, ಇವತ್ತು ದೇಸಾಯಿ ಅವ್ರದ್ದು ಆದ್ಮೇಲೂ ನಾನು ಸ್ವಲ್ಪ ಹೊತ್ತು ಕೂತಿದ್ದು ಎಲ್ಲಾ ಸೈನ್ ಮಾಡಿ ಕೊಡ್ತೀನಿ. ನೀವು ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿ ಸೋಮವಾರ ಕೊಡ್ತಾರೆ. ನಂದು ಯಾವ್ದು ಉಳಿದಿಲ್ಲಪ್ಪ. ನೆನ್ನೆದೊಂದು 5-6 ಇತ್ತು, ಅದು ಇವತ್ತು ಬೆಳಗ್ಗೆ ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ. ಇವತ್ತು ಏನ್ ಮಾಡಿದೀನೋ ಅಷ್ಟೇ ಉಳಿಯೋದು. ಇವತ್ತಿಂದ ಎಲ್ಲ ಸೈನ್ ಮಾಡ್ಬಿಟ್ಟು ಹೊಟ್ಟೋಗ್ಬಿಡ್ತೀನಿ. I am also not available there afterwards in the vacation. So I am aware of what is happening. We have checked up. Nothing is remaining to be released. ನೋಡಿ ಹಿಂಗ್ ಕಳಿಸ್ಬಿಡ್ತಾ ಇದಾರೆ ಅಲ್ಲಿಂದಲ್ಲೇನೆ. ಆಗಿದ್ದಾಗಿದ್ದು ನಾನು ಇಲ್ಲೇ ಮಾಡ್ಕೊಟ್ಬಿಡ್ತಾ ಇದ್ದೀನಿ. ನಾನು ನೆಮ್ಮದಿಯಾಗಿರ್ಬೇಕಲ್ಲ, ಅದಕ್ಕೋಸ್ಕರ 15 ಬನ್ನಿ ಆಯ್ತಾ. ಫೈನಲಿ very good, wonderful. What I will do is I will take the compromise petition on record, and that interim protection what has been there and ಕೊಟ್ಟಿರ್ತೀನಿ. ಫೈನಲ್ ಆಗಿ ನಿಮ್ದೆಲ್ಲ ಸಿವಿಲ್ ಕೋರ್ಟು ರೇಟೆಡ್ ಎಲ್ಲ ಆದ್ಮೇಲೆ ಇದನ್ನ ತಿರ್ಗಾ ತಗೊಂಡು ಅಲ್ಲ ನೋ ನಾನು ಹೇಳ್ತೀನಿ ಕೇಳಿ, ಇದನ್ನ ಹಿಂಗೆ ಇಟ್ರೋಣ. ಓ ವಂಡರ್ಫುಲ್, ವೆರಿ ಗುಡ್ ಬರ್ಕೊಳ್ಳಿ. ಒಂದ್ ನಿಮಿಷ ಬಂದೆ, ಮುಗಿಸೇ ಬಿಡೋಣ ಹಂಗಾರೆ. ಮೆಮೋ filed with a copy of the compromise terms. First, heard Sri heard Sri Pradeep CS and PR Pradeep for second de facto complaint and learned HCP. Aitama petition under section 438 CRPC with the following prayer. During the course of arguments, a memo is filed with a copy of the compromise terms to be presented in the civil suit. First, Sri Pradeep CS, Land Counsel for the petitioner, submits that a petition is also filed under section 482 CRPC, which is pending before this court in criminal petition number dash of 2023. First, seeking quashing of the complaint after the dispute interstate between the petitioner and the de facto complainant is sorted out amicably. First, taking note of this, for the next para, this court perused the compromise terms to be filed in the civil suit. First, as per the compromise terms, the petitioner has agreed to clear the respondent de facto complainant has agreed to clear the entire dues on or before 15th of May 2023, whereby the petitioner would return the property to the de facto complainant free from encumbrance. First, next para. In view of the said positive development in the matter, the coercive action against the petitioner, if any, including the arrest by the jurisdictional police, would only act as an obstacle for the smooth settlement of the dispute between the parties. First, accordingly, a case is made out to allow the petition. Hence, following order: petition allowed. Petitioner is directed to be enlarged on bail, taking a bond in a sum of ₹1 lakh if arrested in respect of the crime number so and so. Petitioner shall cooperate with the crime number so and so. Crime number so and so. Crime number 341 of 2022, dated 17/11/2022 of Subramanyapura Police Station. First, petitioner shall cooperate with the investigation agency. Petitioner shall not tamper the prosecution witnesses in any manner. Petitioner shall attend the court regularly. ಅದೆಲ್ಲ ಅದರೊಳಗಡೆ ಇದೆಯಲ್ಲ, ಸಾಕು ಮತ್ತೆ ಬಿಡಿ. ಎಸ್ ಸರ್, ತೊಂಬಿಡಿ, ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಸೈನ್ ಮಾಡ್ಬಿಡಿ. ಥ್ಯಾಂಕ್ ಯು ಆಲ್. ಪಿ ಪಿ ಅವರೇ, ಥ್ಯಾಂಕ್ಸ್ ಫಾರ್ ಯು ಆಲ್ಸೋ. ಸ್ವಲ್ಪ ಪೆಸ್ಟರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀನಿ, ಯಾಕೆ ಅಂತಂದ್ರೆ unless I was little harsh, this could not have been achieved. with the available working days of 32 days, we were able to dispose of 643 criminal petitions. Thanks for all.